Good morning, everybody. It's 9:30 and this morning's hearing session is now open. So welcome back to those who were here yesterday and to those who are just joining us today. Welcome to the examination of the hearing sessions for the examination of the Telford and Wrekin local plan. For those that weren't here yesterday, my name is Mike Warden, and along with my colleague, Ms. Catherine Carpenter, we've been appointed by the Secretary of State to hold the examination of the local plan. For those who weren't here yesterday, you'll have missed the fun we had on fire practices. So everyone who is here yesterday will know what the evacuation procedure is. But if you weren't here yesterday, it's out that door, essentially, and down to the area behind the building. So we had a fire alarm yesterday and we all had to go out, so it worked okay. So everyone seemed to follow the procedures okay. If you need anything, if you weren't here yesterday and you need anything, Kerry Truman and Ian Bussey are the programme officers, and they're here to help you if you can't find anything or unsure about anything, but most of you will already have had contact with them. If you, we'll have a break mid-morning and probably around about 11 o'clock, but if you need a break earlier, anyone needs a break, then please let us know. Just to be aware that the session is being recorded, so that participants, if you can, please put your microphone on when you speak, but please be aware that the microphones are not for amplification, they're only for the recording, so please speak up. We did have a couple of issues yesterday, so please speak up as loud as you possibly can when you are talking. And if anybody in the room cannot hear, then please come forward. There are some seats closer to the tables, and if you still can't hear, then please let us know, and we might be able to find some spaces at the back over there where you might be able to better hear if that is a difficulty. Just to say that we have a colleague here from the Planning Inspectorate, so if you see us talking to someone, and she is here as an observer from the Planning Inspectorate, so that's who we'll be talking to. I'm now going to turn to Mr. Humphreys, and Mr. Humphreys, is there anything that you wish to bring to my attention before we start?
Only, sir, that we're told whatever the issue was yesterday with the fire alarm has been resolved, and it hasn't been going off overnight or anything like that, so fingers crossed we'll be okay today.
Thank you. Again, just for those people who weren't here yesterday, I'm sure if you've been to local plan examinations, you know the form, but if you turn your nameplate up on its end, and they do stand up, so if you turn your nameplate on its end, if you wish to speak, then we can see that you wish to be brought into the discussion. Thank you. So today we are on to matter 3, and we have 2 issues this morning. The issue 1, which is the approach to the housing requirement, and then issue 2, which is about supply. We will be returning to the supply issue next week, so this is an initial look at 5 and overall plan period supply, but we will then be going through all of the sites over the next, well, tomorrow and Monday, before we return to the overall and 5-year supply position next week. But we have some specific questions for you today. So if we turn to issue 1, which is the approach to the housing requirement, and we had some discussion yesterday in relation to the sustainability appraisal, in respect of unmet need. So we will be returning to unmet need today and looking at that in a little bit more detail. But we'll start with question 26, which is the general approach to housing. I would like to introduce, like the council to introduce the position of them on this, on the numbers, essentially. And if you could refer to the updated topic paper and the updated information, that would be helpful. Thank you.
Yes, sir. I'll get Kirsten to take us through that, but just to set the context in terms of what we're discussing, obviously, sir, what the NPPF requires under paragraph 36A is that in order to be found sound, plans should be positively prepared, providing a strategy which as a minimum seeks to meet the area's objectively assessed needs and is informed by agreements with other authorities so that unmet need from neighbouring authorities is accommodated where it is practical to do so and is consistent with achieving sustainable development. Objectively assessed needs is judged by reference to the standard methodology. The most up-to-date standard method for Telford and Wrekin is 881, and that is what we're proposing through the local plan. So judged against that policy, we say we're sound. But I'll ask Kirsten to jump in. Well, first of all, to introduce herself and then give us some more context as to the figures that we're proposing.
Thank you. Yes, hi, I'm Kirsten Ward. I'm a director at DLP Planning, and myself and my colleague John Goodall were instructed by the council to prepare the economic and housing development needs assessment work, and also some of the additional housing technical evidence, including the housing delivery topic paper and also the technical report that form part of the evidence base. So as Mr Humphreys says, the housing requirement that's set out in the plan is derived from a local housing need assessment calculated using the standard method as set out in National Planning Practice Guidance. Just for context, at the time the plan was published, that figure was originally 857 dwellings per annum, and that calculation was set out in the EDNA, so the Economic and Housing Development Needs Assessment Update, which is document EH01. And to that figure, the council then added a contribution towards the Black Country's unmet need of 153 dwellings per annum in order to form the overall annual housing requirement. And that was in accordance with paragraph 62 of the NPPF, which states that in addition to the local housing need figure, any needs that cannot be met within neighbouring areas should also be taken into account in establishing the amount of housing to be planned for. And that figure that was in the publication version of the plan was 20,200 dwellings over the 20-year plan period. And as Mr Humphreys has said, since submission, the standard method output has changed as a result of the affordability ratio being updated, and also the local authority dwelling stock figures being updated. So those figures that fed into the standard method calculation were updated, and it's that updated calculation that is set out in the section 2 of the housing delivery topic paper, which is TW11. And as Mr Humphreys says, this gave a baseline housing local need figure of 881 dwellings per annum. The contribution of 153 dwellings towards the Black Country's unmet needs, as I previously mentioned, was again added to that figure to produce the revised housing requirement of 1034 dwellings per annum, which equates to 20,680 dwellings over the plan period of 2021 to 2041.
Thank you. And just to clarify that, the change to 2680 results from the moving of the plan period, suggested moving of the plan period, which we discussed yesterday, to 2041.
It's
And a little bit extra calculation as well, is that?
It's primarily due to the change in the standard method output because it's still a 20-year plan period. So it's still the 881 times 20, essentially, plus the contribution to the unmet needs.
Thank you. What I'd like to do is to invite, I'd quite like to break it down if we can. It might not be possible, but I'd like to just understand whether anybody wishes to raise anything about the way in which the council has calculated its own need, and then deal with the unmet need element, if that's possible. So if we can deal with that in that way, does anybody wish to come in on how the council has calculated its need for its own area, and we'll come back to the unmet need element. Stanneman.
As you know from our Reg 19 and our MIQ response, which I won't go into, the HBF believes that the housing need should be higher because of economic growth aspirations to support the delivery of affordable housing for viability reasons and all of the reasons that we normally say about why housing needs to be higher. And we encourage all councils to do more than the minimum standard method, particularly in light of the government's stated ambition for 1.5 million homes, which is the position at the moment. But even at the time the plan was submitted, the previous government still was trying to deliver 300,000 per year. So because, particularly in light of the unmet needs elsewhere in the region, the more that Telford could do to meet the unmet housing needs of the nation and the region, and more housing provision in Telford, the better. Thank you.
And have you put a figure on that?
We generally would request that the council consider it as part of their assessment of whether the need should be higher, one of the options considered in the essay, but we don't give a particular figure. We just say they should consider whether it should be higher, and if it's not higher, they should give clear reasons as to why there isn't an opportunity to provide more.
Mr. Moulton.
Yeah, again...
It's my fault. If you could just introduce yourself. I know you were here yesterday, but if you could just introduce yourself and who you're representing. Thank you.
Okay. Doug Moulton, Director at Inzygo, representing Boningale Homes. So just in relation to that, I concur that the standard methodology is a minimum figure, and we can see that it's already gone up since the submission plan when it was submitted by a number of units. And also we think, you know, to boost supply, and the fact that the area, Telford and Wrekin, has had a really strong delivery rate historically, that there is obviously the ability to deliver more houses in the area, and then that will obviously help and assist in those affordability areas. And obviously the historic delivery rate is sustained inward migration, and just reflects that it is an attractive market area, so there is the opportunity to do more than the minimum, which is the housing requirement figure.
Do you put a figure on that?
Again, I think it should be tested through the evidence base with different scenarios.
I'm sorry, I just can't read your name, please. Mr. Kells.
Yes, it's Gerald Kells. The R should be an L on the nameplate, but I'm been instructed by CPRE. I just want to say we agree with the local authority using the standard methodology. We'll come back, as you say, to the additional housing to meet duty to cooperate. But the point for us is that there is no reason for additional supply except for the duty to cooperate, which is important because, as we know, the housing in Telford is heavily reliant on in-migration. There's not a natural growth to accommodate this. So that in meeting the standard methodology itself, it's heavily reliant on in-migration. We know that in the past, Telford has oversupplied. We gave a figure in our statement. The latest figure, I was just looking on the 2024 housing supply statement, I think is an oversupply of 3,176 above the level that is required in the local plan, which itself was heavily above local need because it was there to encourage the growth of Telford to meet its the size that was considered the right size for Telford. And lastly, we know that it will meet its employment needs, and that's also set out in the EDNA from that standard methodology. So we don't see any reason to increase it. The concern with the standard methodology, it is the minimum, and that's correct, is that it is fundamentally inflationary, as we've seen over a year. Simply the more you build, the more you will be required to build, whether or not there's any demographic reason for that to happen. But that is the system we work under. But that is why we consider that any addition, and if it's an attractive market area or if there's any reason people want to come here, they will be coming from the Black Country predominantly and from other areas. So any additional housing or any additional supply that can be found should be to meet those needs. And because we know that there will be issues when we come to the duty to cooperate in other areas, that should be the purpose. So we don't agree there should be additional housing supply at the core. It should only be as it is needed to meet duty, to meet, not sure we can call it duty to cooperate, needs next door. Thank you.
Thank you much. Thank you very much, Mr. Kells. Do you want to just put your nameplate down, please? Thank you very much. Mr. Humphries, do you wish to respond to those points?
No, sir, I don't think any of those points change or undermine or challenge the proposition that by reference to national policy, we are sound by reference to the use of the standard methodology.
You'd say to the argument about if Telford is a place for economic growth, what about the position that there should be an uplift for economic growth?
Well, sir, what you then get to is you have to also consider things in the round and what the consequence of additional growth would be. And if you recall yesterday when we were looking at the IIA and we were looking at growth scenario 2, which is in essence what the plan proposes, if you were to then look at growth scenario 3, which was a higher growth figure that was tested, then the negative impacts in that higher growth scenario become higher, as assessed by reference to the IIA. So it's not a simple case of, well, why don't you just build more? That has consequences. And so as a matter of planning judgment, we're content that the approach of providing for objectively assessed needs is an appropriate one. And I guess I'll just ask Kirsten to come back in on the specifics of actually the relevance of an economic growth scenario here.
Thank you. Yes, so just to say, obviously, the new standard method requirement, 881 dwellings per annum, it's no longer demographically driven. There's no demographic part to that now, as there was previously, when it was based on sort of household projections. So that's not to say that that standard method requirement, in being a higher number, it could still reflect an element of growth ambition within it. And we did actually test sort of higher than the standard method as it was. I think it was around 457 when we did the original EDNA, and we tested higher sort of dwelling requirement figures at that stage in order to account for the growth ambitions of the district. And the standard method figure as it currently stands is actually very similar, as Mr Humphrey says, to one of the justified alternatives to the standard method that we originally tested under the EDNA at part 1, which was 848 dwellings per annum under the Experian-led jobs growth scenario. So we would say that whilst it is a minimum, it does still reflect some of that level of growth ambition within the district.
Okay, thank you very much. So if we can then turn to the issue of the unmet need. If Mr Humphreys, if I could just turn to you, or Ms Ward, how, just to lead off on this, and then we'll open up for discussion. I just like a point of clarification, if we can, in relation to Dudley. In the post-hearing letter for Dudley, which postdates the date of the statement of common ground between the Black Country authorities, that I think you've got a copy of the post-hearing letter for the second post-hearing letter for Dudley. Have you got?
Sorry, yes.
Yeah, so you've got that. Yeah. So I don't know who might best to answer this, and I realise that none of you are from Dudley, but the post-hearing letter from Dudley, which, as I say, has come after the date of the statement of common ground. I understand, but that if you look at paragraph 16 of that letter, and we weren't at Dudley local planning examination, so we're not familiar with the detail, but the letter says in paragraph 16 that halfway along, the letter 16 says, well, I'll read it out for those who haven't got a copy. The council has provided evidence to support the effectiveness of its interventionist approach to the housing market. I also note the investment in public transport infrastructure that I was able to see on the ground and the availability of external funding to bring forward sites in a challenging market area. As such, given the extent and number of developable sites, I see no reason for the council to rely on others to meet its housing needs. It then goes on to talk about housing supply numbers. But I just wonder whether you're able to clarify to us what the implications are of that in relation to the Black Country's need. Do you know if the letter is talking about something that's separate to that, or does it have implications?
Well, just standing with the first point, we would read that letter in the same way that you've read it, in terms of what it's saying about whether or not there is an unmet need from Dudley, based on the evidence as things stand. The approach of the Telford and Wrekin plan is to make a contribution to the Black Country as an area, rather than to say within the plan, X number are for this local authority, X number are for this local authority. Separately, the Black Country authorities have agreed between themselves a metric which does sort of apportion the 153 contribution that we're made, but for the purposes of the plan, the 153 is a contribution to the unmet needs of the Black Country. And this then sits within the wider position that the evidence suggests that there is an unmet need from the Black Country area, but the precise level of that need at this point in time is unknown because of the stages those various other plans are at. And so we don't consider it causes a problem for our plan. The question, if anything, I guess, would be, in terms of soundness, are we over-providing in terms of a contribution to the other authorities? That is where this would go to. Through our SA work, through the IIA work, we've assessed the global figure of housing that we're proposing and have made a planning judgment that that's appropriate. But if there is an over-provision, that's what it would go to, that is an over-provision rather than an under-provision. And I'll just look down the table to, sorry, Kirsten Ward's colleague is also now here from DLP. I see he's sort of leveraging his stick.
Yeah, good morning, inspectors. Yeah, just to assist as well, to put that Dudley matter into context, you do have Appendix C to the Council's response to your initial questions. I've got it at TW01B, Annex C. And it just shows some of the initial work that was done under the duty to cooperate in terms of migration flows. But probably the most important figure there is the Dudley figure for unmet needs was only 699 when that work was carried out. So when you actually ran through the Council's migration rates methodology, yes, it's a different calculation, but it was actually only 36 units that contribute towards the Dudley answer to your initial questions. So really that issue was already on the table to an extent. We knew that the Dudley unmet needs figure was lower than other authorities in the Black Country, but that doesn't dissent from what Mr Humphreys has just said. It's a single Black Country figure, and it's also justified within the EDNA evidence base as a whole in terms of that wider relationship with economic growth ambitions and migration flows over time. But certainly in terms of Dudley's extensive unmet needs, you already have a position on that in the Annex C response. And yet it's by far the lowest figure of the four Black Country authorities.
Thank you. That's helpful. Mr. Wildsmith.
Thank you, sir. I was actually at the Dudley EIP, so I could probably shed a bit of light. But Mr. Goodall's actually sort of jumped the gun there and picked up on the fact that the lion's share of unmet need coming out of the Black Country is not from Dudley. It was a fairly nominal figure in the scheme of things under the current plans that have been submitted. As Mr. Goodall said, it was about 699, and that seems to have ostensibly gone down in the post-hearings letter, suggesting that there is a bit more supply in the Black Country that could meet those needs. But, you know, when we look to Sandwell, Walsall and Wolverhampton, those needs are still incredibly high and need to be addressed now. And I would also point out that these plans in the Black Country are under the transitional arrangements and will very, very shortly need to be undertaking a review under much higher standard method figures, and that need then goes up even further. So in terms of being sort of proactive and future-proofing this plan, I think the Council's done a very admirable job in that sense. Thank you.
Thank you, Mr. Wildsmith. Mr. Green.
Thank you. I just wanted to make a more general point, really, and referring to our, it might help to refer to our Regulation 19 submission from, say, paragraph 210 onwards. What strikes me is, I know we've referred to the new standard methodology, which no longer refers to demographic need, but one cannot ignore demographic need. I ask myself the question, who is it who is going to come to live in these 1,010 houses that are proposed to be built every year? Demography tells you it cannot be the people of Telford. paragraph 437 of the plan states that the council are planning to meet the future housing needs of the borough. Then they're not. They're planning to meet needs of other people as well. So my point is that of the 1,010 houses, a lot of them will be lived in by people from the West Midlands, not by people from Telford. So in reality, the plan is proposing that more than 157 houses per year will meet unmet need from the West Midlands, because the 1,010 houses, as I say, will not be lived in by people from Telford Borough. They will be lived in by people probably from the West Midlands. So they are providing a larger amount than 157 houses as unmet need. That's my point. Thank you. Can I pass to Gerald?
Yes, indeed. Yes, Mr. Kells.
Thank you. We did just, to try and be helpful, we provided some matter in our statement to look at the potential for where we were in terms of Black Country unmet need. The difficulty with the statement of common ground, of course, is that it is essentially out of date. Under the table, it's paragraph 1.40. It didn't get a table number, which was a mistake. And you'll see it there, and it's got the authority, the plan stage, the relevant MPPF, and the shortfall as we calculated it. I should just note there is a slight mistake. So on your copy, you can cross out the words used in the statement of common ground, because it's not. That was from a previous document which somehow stayed. Those figures are given by us. And you'll see the figure of 699 for Dudley. Sandwell 15916. So Sandwell is by far the largest shortfall. Wolverhampton 10398. Those are all the three that are under the transitional arrangement. And we have someone from Wolverhampton who may comment on that, but that's as I understand it. You then have Walsall, which is at regulation 18, and we calculated had a shortfall of 3,600. They are saying they have a shortfall of 4,979. We think there's slightly more supply. So the figure we've given you in 1.4 is optimistic, because it's our view, not the local authority's view. The further complication in terms of shortfalls is the situation in Birmingham, which of course has dramatically changed under the new NPPF standard. Unlike everywhere else, its need has dramatically fallen, and according to them, they have a surplus of 13,306 at regulation 18, and they are currently in discussion. As I understand it, we had a meeting on Zoom with them. They are under discussion about whether there is additional supply, and also about how that might be distributed, because obviously the Black Country authorities have an interest in that overspill, as do places like Solihull and others. So when we take that table together, we believe that Birmingham has more capacity. So our capacity in our table is 23,000. So again, we've taken a more generous approach than the local authorities have taken. And that shows a shortfall of 30,635. But if you take the Birmingham and Black Country together, it's 6,700. Now, that, of course, not all of Birmingham's excess housing, even when it's agreed, it's all up in the air to a degree, would go to the Black Country. So on whatever metric you look at, there is a need for additional housing to meet need in the Black Country. It's also got to be taken into account. I'm from Walsall, so I'm very aware of the plan that's going through, and I'm very well aware of the controversy around sites that are in the that figuring involves still some, I can't remember the exact figure, but a large number of housing which is in Walsall's Greenbelt in extremely sensitive locations, most of which are not grey belt. So whether all the allocations in the Regulation 18 will go to Regulation 19, we will have to see. But clearly there is a case that some of those allocations have environmental impacts. So the outcome of that is that even under the new MPPF, and someone has mentioned that some of these may have to review and their shortfalls may increase, there are shortfalls in the Black Country that should be met by local authorities. It is correct that Telford is meeting some of that. We know that some of that housing will, that people who move to Telford will come, probably predominantly from the Black Country, to come here. The last point is that, as I understand it, the figure, which is a balancing figure, is also justified on the basis of commuting rates. I'm not sure that those are the best way of looking at it. It seems to me that the question is if there is capacity within Telford to meet some of that need in a way that is sustainable and more sustainable than some of the options, particularly in Walsall, that have been considered, then it is appropriate that that figure should be identified. Now, when we come on to supply, and particularly to windfalls, we will suggest that that figure could be higher than the 153 that is currently suggested, but I'll leave that till we get to that matter. I hope that's gives a helpful update on where we see it coming. But as the council say, it is fluid because those discussions are ongoing, and there is not a current statement of common ground.
Thank you, Mr. Kells. Mr. Hawley, you had your nameplate up, and then I'll come to Ms. Osman-Smith.
Thank you, sir. Just a short comment from me, building upon the comments of Mr. Wildsmith. My understanding is that the Dudley plan was prepared under transitional arrangements using the old standard method housing figure, and apologies if I got these figures slightly right, but it was based upon the provision of 657 dwellings per annum. Under the new standard method figures, once it's revised, it'll have to deliver 1,462 dwellings per annum as a minimum. So there is a significant amount of unmet need from Dudley on the horizon. So any suggestion that the numbers should be reduced because of Dudley's current position, I don't think really stack up. And I was going to make a brief comment on the Birmingham plan, but I don't think I will in the context of the fact that obviously we don't know what final housing numbers are going to end up in the Birmingham plan at the present time and what sites will ultimately be allocated in it. But I deal with Birmingham quite a lot, and I understand that the capacity to accommodate additional development isn't quite what's being suggested by some.
Hawley, Ms. Osman-Smith.
Thank you very much, and good morning, sir. Good morning, madam. As Mr. Wildsmith said, the need is incredibly high from the Black Country authorities. The housing delivery paper housing delivery topic paper records that at in excess of 3,000 dwellings per annum. And the question is, in that context, has the figure of 153 as a contribution from Telford and Wrekin been justified? And we say the answer to that question is no, for reasons alighted upon yesterday and for some more that I'm going to give you now. There has been a lack of assessment of that need, or indeed any other alternative figures within the integrated assessment as a component of the plan requirement. It's just assessed as an overall requirement rather than trying to understand really capacity, whether Telford and Wrekin has the capacity to do more, because the starting point is the council accepts it's going to help. Well, that's great. The next question is how much, and we end up with 153. And that's a fraction, of course, of the unmet need. But where does the figure come from? And as I said yesterday, it's just an outcome of the figure planned for minus the requirement for Telford and Wrekin alone. It's a consequence of that calculation. And I still search in vain for justification of the 153 that goes beyond that mathematical calculation. We're told that migration has been considered in arriving at that figure, but that's a population, of course, that's already moving between locations. The unmet need is a different question. It's a need arising in areas that can't be accommodated there. And the migration figures aren't necessarily an accurate proxy for what the unmet need contribution should be. And so I say capacity is a really key question here. Does Telford and Wrekin have the capacity to do more in the face of overwhelming need from the Black Country? And there's been no assessment of that for the reasons set out in the IAA that we looked at yesterday. What that says is simply that a figure in excess of 1,000 dwellings per annum isn't deliverable because housing delivery is plateaued, and we explored whether or not that was the case. And my submission is that it's not, that is wrong. But it does remain the case that Telford and Wrekin is a relatively unconstrained authority, particularly in the context of authorities in the Black Country, of course, and those that sit around it has no greenbelt, for example. So it should be looking to do more. The figure should be higher. Thank you.
Thank you, Ms. Osman-Smith. And do you say what that figure should be?
No, again, we come back to the fundamental problem yesterday, that the alternatives haven't been assessed as part of the integrated assessment appraisal. So it's very difficult to understand, without understanding the capacity of the borough as a whole to accommodate greater needs in a sustainable way, of course, which has to be the fundamental question, what could actually be accommodated. So the context is overwhelming need from the Black Country, relatively small proportion from Telford and Wrekin, but based on a figure that hasn't been justified at all. So, no, I can't offer an alternative. That would have to be subject to assessment, but it does seem a pretty meagre contribution.
Thank you. Mr. Humphreys.
Thank you. I'll learn by the end of the 3 weeks. So, if inspectors, if I may just give you both a couple of NPPF references, ones that we've already looked at, but 36A, again, as I've just referred to previously, but also paragraph 28, which we looked at yesterday, which recognises the fact that plans come forward at different times and the evidence therefore necessarily reflects that. And clearly you've got a good example of that here in relation to what's happened in Dudley versus where we are in our process, and their position has shifted, which therefore and so the most up-to-date position in relation to Dudley is in essence what you've got from the inspectors that we looked at earlier in relation to their unmet need. And then in terms of informing what we should be providing, if anything, in relation to unmet need, again, the reference in 36A is that what you should be looking at to do the way you consider this is by informed agreements with other authorities, and that's what you have here. And you have that both with the Black Country Authority specifically, but also then the wider West Midlands Statement of Common Ground, which is a document that is in essence a perpetual document. It gets updated every time one of those authorities moves further along in a particular plan-making process, and we're continued signatories to that, reflecting our role in that wider housing market area. What neither the NPPF or the PPG does is give you any sort of methodology to assess the level of contribution that should be made for unmet need. That doesn't exist. And so what you have to do is have regard to the existing evidence and make a planning judgment. And we're content that the one we've made is sound in that regard. In terms of the genesis of the 153 figure, it stems from, obviously, as a lot of these things do, numerous documents. But the position is well summarised in the attachments to the duty to cooperate statement. So you have at TW01C is the letter to the Black Country authorities on the duty to cooperate. And what that identifies is that we'd originally proposed based on, or we'd originally considered based on migration data, the figure of 80 houses, which then moves forward in time again as evidence is updated and migration, amongst other data, is referred to get to a figure of 126. We do have capacity work. We obviously disagree with what's said on behalf of Boningale in that regard, and it's a point we discussed yesterday, so I don't need to reiterate that. But we have got capacity work in the IIA, which identifies the sustainability impacts of different scenarios. But we're comfortable that a contribution of 153, which is above what the migration data would suggest. Migration data is a perfectly reasonable proxy to use for this sort of things. That's been agreed by the Black Country authorities, and we see that in the we see that in the statements for these MIQs. They recognise that as appropriate method. Because we know through our capacity work that we can do a bit more, we're content to provide that. But if anything, actually, the question would be, are we actually doing too much? Because the data would suggest that a lower figure would reflect our role in the housing market area. But we're content as a matter of planning judgment with the approach that we've made, and that's a sound one.
Are there any other points? Oh, I'm sorry. Is that Ms. Ross? Is it? Thank you.
Thank you, sir. Yes, it was just to draw your attention to the Greater Birmingham Black Country Housing Market Area Statement of Common Ground, TW15A, in paragraph 5.7. It does state that where it is evidence that a local authority in receipt of the contribution no longer requires the contribution share or has met its shortfall, then the surplus contribution will be apportioned to the remaining local authorities where relevant, which I would suggest may apply to the Dudley situation following that letter from their inspector, potentially. And also to reiterate, yes, that the Statement of Common Ground, it is intended to be updated every time that there is a material change to a plan covered by the Statement of Common Ground.
Thank you. Ms. Osman-Smith.
So yeah, just on the migration point, I'm looking at the Statement of Common Ground, I've got it in the duty to cooperate appendices. I'm also just checking the latest one that we've had, and it does say the same thing. It's paragraph 5.4 within that, which talks about migration flows being used as the basis for apportionment of the unmet need between the authorities. Totally agree, that's appropriate. That would be the best data set to use for that activity. But in terms of informing what Telford should be providing based on those, I'm really struggling to see the link. And when I look at the housing delivery topic paper or the needs assessment that sat behind that, the reference to the 153 figure is so scant as to be of no assistance in understanding really where that figure comes from or the extent to which it's been assessed.
Thank you. Ms Ross, you've got your name plate up. Mr Humphries, do you want to come back on that?
The totality of what we're proposing to be, I'm not really clear what is saying has not been assessed. The totality of the housing proposal through the local plan has been assessed, and therefore the 153 has been assessed. I mean, that's the simple answer.
Well, Smith.
Thank you, sir. I would echo Mr Humphrey's former statement prior to that one, just about basing everything on the available information, and also the point that we are told to distribute needs, and at no point does the PPG nor the NPPF give us any mechanism to do so. And to the point Ms Osmond Smith has made around migration, I would draw everyone's attention back to the two arguably most successful distributions of unmet need being Coventry and Warwickshire and Leicestershire, which used a functional relationship-based model, not too dissimilar to one that I myself have drafted, but it uses migration and commuting patterns alongside other factors. And if we were to do that exercise, and certainly I have for Telford, you would see that broadly the 153 is aligning with what migration and commuting patterns would suggest in terms of meeting those needs. So, I would wholly support the Council's position that its level of unmet need contribution is appropriate in this instance.
Ms Danneman.
I think the issue here is maybe that it's not justified because the council's clearly done something to come up with a figure and made some assessments, but the plan doesn't say that. So the solution is probably a main modification to say where the 153 comes from, assuming it comes from somewhere and assuming it's been rooted in the evidence and assuming it's been properly assessed. So that would seem to be the solution to this issue. That our position is you should do as much as possible, but whatever you're doing, it still needs to be clearly justified and explained where that figure comes from, because at the moment it feels like it is a residual calculation rather than a proactive, positive, justified, effective choice. I'm sure it is, but that's not explained.
Mr Wells Smith.
Sorry, just to jump in and just draw everyone's attention to the PPG. Where authorities plan for a higher growth than they should normally have, this does not need to be thoroughly justified at examination. This is the case here. The authority is planning via its contribution to make a housing requirement far in excess of its standard method figure. So it doesn't necessarily need to be thoroughly justified.
Sarah, I think that's absolutely right when you're talking about the borough's own need. What we're talking about here is the outcome of cooperation in meeting another need. So that it can't be viewed through the same lens.
Does the council wish to come back on those points?
I'm not sure I'd be saying anything new, sir, that we've not already said. And, classically, you don't want to hear me saying the same thing for the next 3 weeks, so I won't.
Can I just turn to a point that Bonningdale's made yesterday, and which is in your statement, which is about the separation of the area requirement and the additional unmet need, and you referred to Shropshire, and I thought, well, we'll come back to that in this session. So would you just like to explain to me what it is that your argument is on that position of separating out those two figures?
Yeah, I think there's a substantive and a procedural point with it. I think the substantive point is understanding essentially the genesis of the two figures we've got, the area need and the need to meet the Black Country's unmet requirements, and how those fit together. Because it's only when one understands how they fit together that you really understand what Telford and Wrekin are doing for itself, and what it's doing for the Black Country and why. And it's been unclear because of the issue of unmet need, where that figure comes from and how it impacts on what Telford and Wrekin wants to achieve for itself. Because of course now it's saying, well, we're giving 153 to the Black Country, so we're doing the bare minimum. And is that appropriate? That wasn't the strategy upon which the plan was progressed initially. And certainly at Regulation 18, when it was planning for higher than its own needs, no mention at all was made of the Black Country. So did the local authority start out being more aspirational for itself, and then has simply said, well, actually now we've got the housing requirement generated by the standard method, so everything else goes to the Black Country and we'll just do the bare minimum. So that's sort of the substantive point, is the interaction between those two figures. The procedural point goes to how is it all monitored when the plan comes into force. What does one do with the unmet need? How do you understand if it's being delivered, where it's being delivered, that sort of thing? That's more the practical consideration. And no doubt, Sir, Madam, you'll be aware of those cases which are coming forward dealing with local authorities and their plans that make provision for unmet need in neighbouring authorities. And inspectors are being asked, when looking at the housing land supply, well, is a discount necessary to reflect the planned strategy to deliver housing in a neighbouring authority? So inspectors are having to grapple with that at the moment, particularly where plans don't have a monitoring provision or an understanding of how those figures are to work together alongside the supply of housing. So that's probably something that needs to be considered to avoid days' worth of Section 78 time being taken up, as I had to recently do, about what we do with authorities which are planning to meet needs but haven't got a mechanism in their plan to understand how that's to be reflected in the supply.
On that latter point, how would that be, is that a soundness point?
Yes.
For this plan?
Yes.
And is that resolvable, in your view, through some wording
yes.
or within the plan?
Yeah,
that will
and I think it would be far more effective if it was, for the reason I lighted upon, that it will take at least a day's worth of inquiry time to debate what one should do with the supply in such circumstances. So it's much better for the plan to set that out. So that those triggers, I think that we've made those points in our hearing statements as well. What do we understand about the delivery of that need, and how is it to be reflected within the delivery of housing? We made other spatial points as well, but that's going back to yesterday's discussion. But it really all comes back to, how do we understand the 153?
Well, so first I should say, I think Telford's delivery, they've changed my nameplate in record time. I think this shows their good delivery. In terms of, I'm not sure we should see it as giving housing to the Black Country, because this housing will be people who will come here and supply services and things in Telford. I also think it's important that in terms of duty to cooperate, a local authority or unmet need, a local authority makes an offer as part of other local authorities. So I would not be in agreement with a position which said that the local authority must meet a specific amount of unmet need and the methodology must justify that level of unmet need. I also think the example of Shropshire, I wouldn't agree with using that example. I was involved in the Shropshire examination for CPRE. The concern there about Shropshire's generalised housing offer to the Black Country was that it meant that the argument was given by people who had sites generally in the M54 area, who was concerned that it might be met by housing offers, by housing that was actually being developed on the far side of Shropshire, which is a long, long way from the Black Country. So that question of whether the sites should be identified was far more relevant, I think, in practical terms, in terms of the Shropshire debate, as to whether it could be said to be meeting needs in the Black Country because of the geography. The fact that it's not in a defined location, or whether it is in a defined location, is less true of Telford. So the fact that it's not specifically designed around a specific site does not seem to me to be as relevant or to be the same argument that was put forward at Shropshire. So we're content that it is within the overall package. Whether it should be in the policy that the duty to cooperate part is separated and it starts with the SM figure and then that's put as a separate figure is a minor issue, but whichever way wouldn't make a difference. We think, and I say we'll come back to this, that there is additional capacity that will come forward anyway, and therefore that can supply to the duty to cooperate. But that is different to saying we should be finding additional sites. And I would also make the point that there are downsides to providing additional sites, because you are also taking people away from the Black Country. So there is a limit to how much you want to do that. So, as I say, I think the Shropshire example is not a good one, but I do think that the offer may be increased, but not by increasing allocations.
Thank you. Mr. Humphreys.
Thank you, sir. I'll just ask Kirsten Ward to jump in on the monitoring point, if I may. But just a reminder that the 153 figure is set out in the planning policy, so it's quite clearly identified that that's the contribution being made to the Black Country need.
Thank you. Yeah, it was just to mention as well in terms of the migration flows. So obviously the 153 we have the annex to the TW01B document, which sets out where the migration flow data and the 126 figure came from. But also just to note in terms of housing market areas as well, the evidence that was initially published identified Telford as being a self-contained housing market area, and the largest proportion of immigration to Telford is actually from Shropshire, and the Black Country authorities actually produce quite a small, relatively small proportion of migration flows to Telford. So that's just something worth bearing in mind.
Ms. Osman-Smith.
Sir, thank you very much. We've spoken about Shropshire a little bit for obvious reasons, but the letter that I'm referring to is the inspector's findings following the stage 2 hearings, which was inquiry document 47 dated the 10th of December 2024, which is useful for understanding the range of issues relating to the Black Country need and how that featured and why the issues arose there. But what is interesting to note is that the council there were asked specifically to appraise the housing requirement, both for Shropshire and also for the unmet need arising from the Black Country and what it sought to contribute to that, the 1,500. I haven't got the detail of that before me at the moment, so I don't want to make any submissions on that because I don't know the answers to it. But it would strike me that perhaps looking at the two different requirements, there are going to be potentially different impacts or even aims and objectives to be met by providing houses to meet those different needs arising from different places. And of course, the SA here doesn't do that.
Just on the monitoring point for the council, I mean, is there a point being raised from Bonningdale around that there might be some difficulty with monitoring the local plan that might lead to some problematic inquiries down the line? Because there isn't a separate monitoring arrangement for unmet need?
Well, what we would be monitoring is, for example, the level of housing delivery. And so we know if we're meeting the requirements of the plan, because what we would be looking to monitor is the plan, and the plan sets out figures for us to monitor. So we have a housing supply target, and we know what proportion of that is Black Country unmet need. And we couldn't be required to monitor something that's not part of our plan through the plan. We could only monitor our plan under the plan. It might be that other work is done elsewhere to monitor where other councils are up to and what that means for the wider scenario within the Black Country itself or within that wider housing market area, which we're not actually part of, but we're a signature to the Statement of Common Ground on. But in terms of our plan, given that we have specific figures, I don't see why there would be a soundness issue there.
Ms. Osborne-Smith, do you just want to help us out on that monitoring point? As to, I mean, you've referred to other local plans, but what is it you would seek as a change to the local plan in order to address that point?
So can I come back to you on that so I can see where it might fit into which specific policy? It's simply about making clear that when you're... So this is the issue we had. Inquiry in South Derbyshire. South Derbyshire are meeting some of Derbyshire's needs to the tune of 24% of its overall requirement. So we go along to a planning inquiry. We're trying to understand what the housing land supply is, and the argument arises that there should be a deduction from the supply to reflect the 24% of the that's reflected in the plan strategy of housing to meet Derbyshire's needs. And we argued about it for a day, and that's not the only decision. There have been some other decisions around Warwickshire that have grappled with this as well, and perhaps elsewhere, but I can provide the reference for that to you. And so the argument arose about how do we take this into account? If there's no sites that were earmarked for meeting those needs specifically, then we can't understand whether they've been delivered. Or is it more appropriate to then have a broad brush? Well, 24% of your requirement was to meet Derbyshire's needs, so therefore do you have a 24% reduction from the housing land supply? And that was what the inspector in that instance went with, in the absence of any alternative arrangement that he could hang his hat on.
Because in Telford, the 153 has just been added to the total requirement, and then the total requirement will be monitored through the plan period, because the plan doesn't specifically say site X or site Y is to meet unmet need. It's just put into the total Telford pot and dealt with that simply. Is that approach unsound?
So yes, I don't think it's effective. I think there has to be a better understanding, when one puts this practically into a development management scenario, how one can understand what's happening with the supply and the delivery to inform decisions, particularly around housing land supply.
I can bring you in now, or Mr. Chung and Ms. Danneman, they might have similar points, but Mr.
I'll hand over to others.
Mr. Chung, then Ms. Danneman.
Thank you, sir. I just wanted to respond to the point being made by my learned friend. I had a similar situation in an inquiry in Rugby, and it's all to do with the unmet need of Coventry and how it was accounted for in Rugby and what should happen to the supply in Rugby when working out whether they have a 5-year supply or not. Yes, it leads to these difficulties. There are, as my learned friend says, two sort of broad categories of case. There are those plans which have identified specific sites which were to meet the needs of an adjoining authority, and there are those plans where it's simply a percentage that was, or a number, which was part of the overall supply number of the plan. And those arguments will rage at Section 78 inquiries. But I disagree that somehow something can be done in this plan to avoid that kind of argument coming up in the future. It doesn't go to the soundness of this plan, and there is really, quite frankly, no solution to that issue unless you say we must have a plan which disaggregates the supply and identifies specific sites within this area to meet the needs of the Black Country. And that's just going about planning in the wrong way. That's saying because there may be some problem at a Section 78 inquiry further down the line, we must, when we plan, decide that certain sites must be identified simply to meet the needs, solely to meet the needs of the Black Country. Now that may or may not be good planning, and we touched upon this yesterday. There is no evidence to suggest that particular locations will better serve the needs of the Black Country in terms of its unmet need. What we should be looking at is this plan and having regard to all factors to do with sustainability, whether the growth strategy and the direction which growth is going to go and which sites are selected are the best sites. What my learned friend is suggesting is something where you're letting some other problem intrude onto the deliberations that we have to make at this plan. I understand the point she raises, but it's got nothing to do with the soundness of this plan.
Thank you. Ms. Danneman.
Thank you. I'll premise my comments by saying that the Home Builders Federation represents large builders and small builders and also housing associations. And I think there has been an issue in some places, as I mentioned yesterday, about nomination rights and a lack of clarity about who has nomination rights. And in Harborough, for example, where Leicester City unmet need is being met in Harborough, there have been long discussions at Section 73 appeals about nomination rights, and it's caused delay and uncertainty. So maybe one of the things the council could do in its monitoring framework is monitor where it allows nomination rights from outside of the council area to be provided in relation to at least the affordable housing element of the need, because there isn't clarity about whether all the unmet needs the open market need, whether it's affordable housing need, whether it's family housing. That's a standard problem in the current system that we hope the new system may help to address through the SDSs, but that may be a solution, at least to the point I raised yesterday about nomination agreements and people moving into the area from outside the area in relation to the affordable housing providers.
Thank you. Are there any other points on unmet need that you've not said around the table before I let the council address those points? No, okay. Mr. Humphries.
Yes, just very briefly on the monitoring point, nothing in NPPF, nothing in PPG that says we need to do anything different to what we're proposing to do in the plan. No policy or guidance basis has been pointed to suggest that what we're doing is in some way wrong or unsound. And I, along with many in this room, I'm sure will be guilty of doing this at situations like this, which is getting too hypothetical about planning. If we make a real world point here, how do you say that a person who lives in a particular market house is a Black Country person versus a Telford person? You can't do that. It just doesn't work. And what we're proposing in the plan by identifying a contribution we're making and stating what that is totally fine, and we can monitor those levels of delivery.
Thank you. So I don't have any further questions on this particular point. I suggest now that we take a break, and we'll come back. So if we take 20 minutes, and we come back at 11:05 and move on to issue 2. Thank you. I think there's just one slight. Is there one slight change of people? I'm not sure. Most of the participants are staying, I think. Okay, thank you. Okay, thank you for coming back on time. Thank you very much. We've discussed this morning the issue around requirements, and we're now going to move into supply. We will be dealing with supply a number of times over the next few days. And so today's session on issue 2 will be revisited next Wednesday. But we will tomorrow deal with allocations and go through allocations of the all the allocations that are not sustainable communities, and then on Tuesday we'll look at sustainable communities in relation to policies, and we'll also look at the delivery expectations around there. So for us it's about understanding some general issues on supply, and then looking at some of the detail in relation to sites, and then coming back and trying to sort of pull that together in terms of a 5-year and overall plan supply. There is also a issue about commitments that we do want to go through, but we haven't actually programmed it in because tomorrow we've got allocations. But we would like to go through particularly the major site commitments, particularly in relation to the expectations on 5-year supply. And we can do that today, or we can give you a flavour of some of our questions that we would want to look at in terms of deliverability of those major commitments, or we can return to that at another time. It may well be, depending on how that discussion goes, that we will want something in writing to support the delivery assumptions, and that may well also apply to some of the allocations as well. But certainly in terms of the major site commitments, might want something in writing, so you might need to go away and do something. So we can look through that today in this session, or we can return to it.
Well, inspectors, I think what would be useful for the council would be if, when we get to the end of this topic, which hopefully we do by lunchtime, you gave us an indication of what it was that you wanted to hear about. We can then check over lunch that we've got the relevant team here to give you the answers on those questions, and then if so, we could deal with that this afternoon, and then whether or not something's required in writing, obviously then we can programme when we provide that for.
Yes, we can do that. I think that I think it could work. It's possibly a bit of a squeeze for this afternoon, but it could work. Or we can do it when we come back, revisit it when we come back on Wednesday.
Okay. Yeah. I mean, it's just simply a question of manpower, making sure we've got the right people. I would imagine it is the people we've got here today, but if we think it's going to be a squeeze, then yeah, Wednesday next week's fine to deal with the issue of commitments.
What we'll do when we in this session, we will give you an indication of some of the points that we'd like to raise, to give you an understanding of some of our, I use the word concerns, but it's just things that we just want to want to explore about deliverability, because we think some of the deliverability information is not there before us, and we think we need to see some of that to be satisfied that some of those sites are going to deliver in the 5-year supply in particular. What we'd want to do is run through the helpful sheet that you've provided as on the housing delivery sheet.
This is the appendix to the housing delivery
Yes,
topic paper.
yes. It's not an easy sheet because it's a big spreadsheet, but there is some delivery information in it. But we would like to explore that a little bit more for some of the sites.
Understood.
Okay. Well, I'll return to that once we've concluded. Once we've been through these questions, I'll return to that, and then you can consider where you think you need to go in terms of providing us with some information and when that is best done. So, in respect of this topic, obviously we've dealt with requirement, now looking at supply, and really we're guided by the framework which says that planning policies on paragraph 72, planning policies should identify a sufficient supply, a mix of sites taking into account their availability, suitability and the likely economic viability. And then planning policies should identify a supply of specific deliverable sites for 5 years following the intended date of adoption, and specific developable sites or broad locations for growth for the subsequent years 6 to 10, and where possible for years 11 to 15 of the remaining plan period. So that is the paragraph that guides what we are looking for in this plan in terms of adherence to that policy, that requirement within the framework. So if we look at the 5-year position, and the council has prepared a table that essentially provides 2 different approaches. One with the completions taken account of from the start of the plan period to adoption, and one that doesn't. As I say, we do not know what the 5-year position will be until we have gone through all of the commitments and the allocations to understand whether or not, whether they are deliverable in terms of the guidance in the framework. So we'll do that. We'll be going through all the sites. But for the figures that, the figures that you have in your a table and then in the housing topic paper, you have assumed that all the figures in your trajectory are as they are. So therefore, could you just explain to us where you are, where you think you are on the 5-year land supply position and the difference in the 2 figures that you've produced?
Yeah, thank you. I'll ask Kirsten Ward to jump in and respond to this topic.
Thank you. Yes, thank you, sir. As you've set out there, the table is table 13 in document TW11, which is the housing delivery topic paper update. The table here, as you've said, shows 2 alternate 5-year housing land supply on adoption positions, and this is assuming adoption during the year 26-27. So it shows the position for the 5 years from 2026-27 through to 2030-31. The figure in the left-hand column of that table shows a supply figure of, well, in both columns, sorry, shows the supply figure of 5912 for that 5-year period. The difference between the 2 columns is that the first column makes an allowance for the expected completions that will have taken place from the start of the plan period, so from 2021-22 through to 2025-26, and that is assuming that there will have been 7,057 completions during that period, leaving a residual requirement of 13,623, which once you've calculated the addition of the contribution to the Black Country's unmet need, the 5% buffer, that gives you an annual requirement equivalent figure of 954 dwellings. If you compare that with the supply, that then gives you a year's supply of 6.2 years, and that is approximately 480 units in excess of the 5-year requirement of 5,429 units. The column on the right-hand side just doesn't take account of existing completions, essentially. So it just works on the basis of the annual requirement being 1,086 units. And then comparing that to the total supply of 5,912 gives you a year's supply of 5.4 years. So whichever method you apply, our expectation is that the plan will have over 5 years' supply upon adoption. We'd argue that the position, which is 6.2 years, is accepted by PPG, which states that where areas deliver more completions than required, the additional supply can be used to offset any shortfalls against requirements from previous years. So that's the justification for presenting that 6.2-year figure there for you.
Thank you. Can I invite any responses to that from around the table in terms of the approach that the council has taken to 5-year supply, notwithstanding that individual sites that we will go through may well affect the supply, but are there any points to be made on the council's approach? Ms. Danneman.
I'll just make a general observation because we don't make any comments on individual sites, but as you will have noticed, various construction companies are going bust at the moment, and I think the market is more challenging. I recognise that Telford is a more affordable, desirable place to build than in other places, but we are just mindful of the kind of challenges facing house builders. In relation to affordable housing, there's a challenge in getting affordable housing partners, and that's causing delays to delivery, sometimes of many months, sometimes of years, as we have to go through the clearing process to show that the affordable housing is not deliverable, and then you apply a cascade mechanism, and just everything is taking longer. And of course, there's a general point about resources in planning authorities and delays to planning applications being processed. So our experience is it's taking longer than people think to get an application permitted, and it's taking longer to get through the process of building the sites once it has been permitted, just as a general point of the challenges facing the sector.
So your point, if I understand it, is that you think that some of the assumptions in relation to delivery are optimistic?
Yeah, I'd suggest a cautious approach is adopted rather than an optimistic one in the current climate.
Making that point now because you don't get involved in individual site discussions.
It's a broad point for every site, and I wouldn't want to repeat it on every site, so we don't comment on individual specifics.
Are there any other points in relation to the soundness of the council's approach on that 5-year supply calculation? We'll come on to look at windfalls and later on, but in terms of 5-year supply calculation, no points to be made. Just if I ask the council, just to understand, so we were talking about, so it's 5 years from the intended date of adoption for the plan. The intended date for adoption, as we discussed yesterday, as the council see it, is end of December 2026. So the housing information, your housing monitoring information, you've now updated it to run from 1st of April 25, is that correct? So the most up-to-date information is 1st of April 2025.
Yeah, with the last year of completions data we have is for the period April 24 to April 25.
You mean the so when you were looking at your completions, you've done an estimate then of the 25-26 completions. Is that?
Yes, that's correct.
When would the data for 1st of April 26 be available? When would that normally be available? When would the council normally publish that for the year?
In terms of when we collect the information, we would normally try and get that as soon as possible. In terms of previous collection methodologies, it's taken a bit longer, so a bit towards the kind of back end of the year, but we're trying to speed that process up at the minute.
Just so I understand, so you said it could be done as quickly as possible, but it would be, did you say back end of the year?
We could probably get that done quicker, sir. I would say probably by the end of May.
Sorry. Are there any questions that people wish, any points that people wish to make on the 5-year land supply? Obviously, we will come back to this when we go through the sites. Okay. Okay, can we just turn to the overall plan period supply? And can the council just outline its position, its expectations as to where it will be in relation to the period post 5 years? Thank you. Again, we will go through all the sites, which will possibly affect some of the numbers. But where we stand now, if you could just highlight Council's position, please.
Thank you. So, in accordance with MPPF paragraph 72B, the Council has identified supply on specific sites which are considered to be developable within years 6 to 10 and also within years 11 to 15 of the plan. And these are clearly set out in document TW11A, which is the housing delivery sheet. I'm conscious there's quite a lot of tables in there, but the table showing developable supply on the housing allocations starts from page 5 of the PDF onwards. And in terms of those on housing allocations, there are 6,913 units expected to be delivered within the period 2031-32 to 2040-41. The developable supply on major site commitments, so those are sites with planning permission, those start on page 10 of that same document, and there is actually just one site there on the major site commitments which is delivering after 2031, and that is the land north/east of Greenways Farm Shop, and that's for 28 units which are due to deliver in 2031-32. So in total, the Council's identified a supply on specific developable sites of 6,941 units in total.
What does that give you in terms of the estimated oversupply for the plan period?
So, if you just bear with me 1 second. So over the total plan period of 2021 to 2041, there is expected to be a total supply of 21,110, which compared to the requirement of 20,680 is a surplus of 430 units.
That 400, just tell me about that 430 in terms of that level of surplus or headroom or whatever it might be. What do you think? Do you think that is? Well, tell me why you think that is sufficient.
I mean, so we've obviously we've accounted for sort of the deliverability of the sites and taken that into account. So we're confident that the sites that we've got in the trajectory delivering on the years specified will come forward. There's also an additional 1,500 or 1,595 sites on housing allocations which are expected to deliver beyond the plan period as well. So there is potential that those might come forward sooner as well, which would give some additional supply within the plan period itself.
But they're not expected to. On your anticipation of delivery, they're not expected to because you've put them.
Not in the trajectory that we've presented here, no.
We will look at individual sites as we go through, but one of the points that you've made is the expectation on lead-in times and delivery rates, and you've had regard to the start to finish report. I think Bonnie Gales have said that I think your words were that your delivery rates were slightly higher on some sites. And in Bonnie Gales, you've picked that up. Can we just have a look at that a little bit? Obviously, as I say, I keep saying this, but when we go through individual sites, there will be obviously a look at the expected delivery rates on them. So what we're looking at now is some of the overall approaches. So perhaps I'll just turn to Mr. Moulton and let him explain the point that Bonnie Gales have set out in their representations, and then I'll invite the council to respond to that.
Thank you very much. I think, yeah, the key thing is we just consider that the lead-in rates are very over-optimistic, and against the Lichfield start-to-finish data, the councils say slightly higher, but for units of 1,000 to 1,499, they're saying 49% above those rates, 35% above the leading rates for 1,500 to 199 units, and then they're 30% above the 2,000 units and above. And obviously that's really important to this plan on delivery, because we've got such a big reliance on the 3 sustainable communities. And obviously, if you just applied the 138 dwelling per annum against the Lichfield rate on those larger sites, you would then be knocking out 1,849 dwellings overall out of the plan period, which would actually get you underneath the total plan period. So it's a real key issue there. The more detail is set out in our hearing statements about that, but I think it's just that reduction of the SCSs from 6,955 to 5,106 when you put in a more standard, industry standard rate. And again, I probably should have referenced this under the previous question, and I don't want to get involved in the more detailed stuff. But again, it's the 5-year housing land supply. Again, it's very optimistic. And when you look at the topic papers for all 3 SCs, you know, there's reference to design briefs and pre-applications and screening, and some very tight deliveries, with SC1 delivering in 28-29 and SC2 and 3 in 29 and 30 onwards. So you're talking 2 to 3 years to get through planning, discharge conditions, 106, complicated infrastructure, and get on site, mobilise and build. So I just think there's some just over assumptions in the housing trajectory.
Thank you, Mr. Wilson.
So, thank you. I'm Ian Gilbert from Stantec, and we're on behalf of Northern Trust Land Limited. Just to add to that point, if I may, sir, that my reading of the council's lead-in times were that it based its assumptions on the Lichfield start to finish 3rd edition, table 3.1. And a median time taken for sites to be delivered, and for example, so taking the 2,000 plus site sizes, was 5.1 years. My reading of the Lichfield's work is that it's 5.1 years to get through planning, and then an additional 1.6 years for those sites to actually get on site. So I mean, it's for you to ask the question, sir, but I wonder if that's the correct figure in table 11 of TW11. Do the council really mean that that's the lead-in time for a site to get on site, or is that the lead-in time for it to get through planning, and is there an additional time frame for it to actually start on site, sir?
Mr. Chung.
Just putting down a marker for the time being that we don't agree with what's been said about the delivery rates on the SCs, but there's a specific question about that later in the programme, so we'll come back to that then. So I'm just putting a marker down just to say that we don't agree with the remarks that are made, but as you're going to deal with the SCs and the delivery on those in more detail later, I'll just be repeating what I'm going to say now.
Stand.
Good morning, Inspectors. Mark Rose from Define Planning and Design, and we're representing Bloor Homes, who have land interests in the Bratton Sustainable Community and in the Muxton Sustainable Community. And yeah, I agree with Mr. We're going to come back to this, but just to make a general point about the start to finish, which is obviously a very useful tool that looks across a range of sites and does help to provide an indication of likely lead-in times. But the issue here is with all three sustainable communities, certainly the two that we're involved in, and the input that we've had into the topic papers, sir, is that we're responding to a specific set of circumstances and reflecting the specific work that's been done to bring forward those planning applications within those timescales. So we can go into the detail of that in more on next week probably, but just to highlight the point in relation to Bratton very quickly, which is the one that's intended to deliver first. We have already been through a pre-app, we have already been through a design review, we've prepared an environmental impact assessment, and in fact the application is ready and sitting in our office for submission, and is due to follow these examination hearings, sir, to confirm delivery and to support the council in its case around the deliverability of the site within the timescale set out in the topic paper. But like I say, we can come to the detail and a bit more next week.
Yes, we will go through those sites on Tuesday. Can you turn to the council then, please, to see if we can pick up those points on start to finish?
Yes, briefly, sir. TW11, the housing topic, housing delivery topic paper, provides justification for the delivery rates we've chosen. I'd just highlight in particular paragraph 6.6 of that identifies that the rates we used are based on local knowledge and the house builders are active within Telford, whereas obviously house start to finish is based on the national picture. We've gone for an informed local approach. And I just note that the comments made in this regard sit within the context that this morning on behalf of Boningale, Mr Moulton described our delivery rate in Telford as a really strong delivery rate, and that's the track record we have in Telford, and obviously representations have been made that we could and should be taking more housing because we've proven that we can deliver that. But I'd just ask Mr Ashford to just come in on Telford's record of approving planning permissions and the timescales that typically takes.
Yeah, thank you, sir. Telford and Wrekin's development management team are a platinum grade development management organisation, so they're recognised by the planning inspectorate as having a very high level of delivery in terms of meeting all the targets to grant planning permissions. So I think at the minute we're at 100% in terms of meeting our kind of timescales and targets for delivering planning permissions.
So is that the justification for having, assuming on some elements, higher delivery rates than the Lichfield start to finish report?
That latter point there was just really to respond to the point made about lead-in times. Obviously, only an element of that is within the gift of the council to control, and we provided you some evidence in relation to that. But know that in terms of the housing rates of delivery, like I say, if you look at the totality of what's in section 6 of the housing delivery topic paper, you have a range of factors that have taken into account there. For example, the point I've made about it's based on local information rather than simply relying on national information.
What sort of local information would that be?
Who the house builders are within Telford and who the house builders are going to be on these sites and what the rates of delivery in relation to those bodies are within Telford.
When we come to look through individual sites, then you'll come back to that point, presumably.
Well, yeah, speaking here in the broader context, but yes, when we get to individual sites, you'll be able to form a view on that individual site.
Are there any further points that people wish to make on the overall approach to lead-in and delivery? Okay, well, we will come back to, I mean, I've got all the representations in terms of the, sorry, oh, yeah, Mr. Milson, sorry.
Sorry. Just about lead-ins, and obviously in the topic papers, and obviously I know what the council say about the delivery and their platinum, and that's really good to hear and what we need as an industry, so I support that. But I think it's just about the Lawley. They referenced the Lawley SUE about providing strong delivery rates, and obviously that was an SUE for 3,300 homes, granted outline in 2005, and it had an outline across the entire boundary with an environmental impact assessment for the site and then a design code, and that sort of shows up that really joined up approach to a large site which can work. And I suppose, again, this is something to go back for later in the programme, but I think it's just that approach to complex sites and lead-in times.
Thank you. Ms. Tunneman.
again, not about specific sites, but in general, the cumulative impact of increasing regulation and things like the building safety levy are adding to viability challenges. So we are seeing more challenges on a site-by-site viability appraisal, even with plans that have just recently been adopted. And I'd also highlight my pet project BNG. We're finding BNG is causing delays in time, it's impacting on densities that are deliverable, it's creating confusion, and the fact the government's changing the BNG policies as we speak will add to that confusion and has the potential to create larger delays because there is uncertainty about how you deliver BNG on-site and off-site, and the market is still establishing itself. Again, we might pick that up further in the nature policies, but it affects delivery and it affects how quickly sites can come forward.
And Ms London, what's your experience, what's your members' experience of Telford, of delivering in Telford?
I think generally the perception is that it's easier than in some other places, and the council is more pro-growth than in other places, and the NIMBYs are less vocal than in other places. But other than that, I don't think there's anything I can particularly say that they're better or worse, but there does seem to be a commitment to processing planning applications, which is sadly absent in many other local authorities.
Okay, thank you. Can we look at, sorry, did you want to come back on anything?
No, I think all the points there are ones that there'll be then specific questions about later, which we can pick up at the appropriate point in time.
Thank you. Can we just look at windfalls and lapses? So we start with windfalls. And you just explain the position on windfalls. I think you've not allowed for major windfalls, but you've allowed for minor windfalls, and there were some representations around the appropriateness of and nature of that. So could you just take us through, and then I'll invite people to make comments on that. So if we just deal with windfalls first.
Yeah, thank you. So the windfall allowance that's been applied within the plan is 120 dwellings per annum, and that has been applied from 2028-29 onwards, which is the 4th year following the anticipated date of adoption, and that's in order to avoid double counting with any existing small site permissions which are expected to deliver within the first 3 years. So the total windfall allowance applied over the plan period is therefore 1560 dwellings over 13 years. The evidence that provides justification for that windfall allowance of 120 dwellings per annum is set out in document TW11, which is the housing delivery topic paper. And if I just draw your attention within that to table 7, which shows the annual average windfall completions on minor sites over the monitoring period for which we had data, which was 2013-14 to 2023-24, and that figure was 126 dwellings per annum. So that figure of windfall completions on minor sites has been fairly consistent when averaged over either that full period or the last 3 years, or the last 5 years, or the last 8 years. So there's a consistent average figure coming out there of around 120 dwellings per annum, which is the figure that the council have chosen to include. And that's therefore considered to be a fairly reliable source of windfall supply on those minor sites. Windfall completions on major sites have also been assessed, although those have been more sporadic over that period. So there have been some large windfall completions on major sites, but it's very lumpy in terms of when they've happened. So that was therefore not considered to be a reliable source of windfall supply, which is why it's only been applied to the minor sites.
Does the strategy of reliance upon the sustainable communities as a significant component of housing growth in Telford, does that come into play in terms of any on the allowance you should provide for windfalls, for more small windfalls for minors? What I'm saying is, does that in any way suggest that the number of minor windfalls coming forward will be less?
I wouldn't have thought so, because it's limited to supply on sites of 10 dwellings or less, so it's very minor. So it complies with the definition of minor set out the MPPF, so it's very small sites. So I don't envisage that it would be different levels of house builders that would be developing those minor windfall sites compared to the sustainable communities.
You're satisfied that those small sites, those small windfalls, are not going to dry up? That the expectation is that they would continue. The evidence suggests that they would continue to occur?
I mean, I can only comment on the period of data that we've looked at, but it does extend back over 10 years, and it hasn't changed within that time. So unless the council have any sort of evidence to suggest that they would dry up, I would suggest that they would potentially continue on that basis. I don't know, Gavin, if you've got anything you want to add there.
Yeah, I was just going to make a point that we've obviously got policy in the plan, I think it's policy HO10, that covers stalled sites. So what we're seeing is in town centres and those sorts of areas, you're seeing commercial sites that would have been former pubs and things like that coming forward. So there is a constant churn of those types of sites coming forward in the borough at the minute. So I don't see there's going to be a position where that would dry up anytime soon, really. I think there's a change in terms of how things are happening.
Okay, any Ms Danneman, and then
Yeah,
Mr.
I think my observation would be, I probably agree that the supply may not dry up, but the deliverability of that supply will become more challenging because smaller builders are particularly facing the problems of biodiversity net gain, of lack of access to finance. And our preference is always for small sites to be allocated because the costs of a planning application, the risk of going to appeal, all of those things that developers sometimes have to do. Again, Telford are not on the naughty step in terms of HBSV and not trying to engage with developers, but I think they are more challenges facing smaller business, and they're going to get worse as the plan progresses. So I think the supply may be there, but whether there's any small builders to build them, whether there's any contractors to develop them, and whether they actually come forward from a deliverability rather than a viability point of view is maybe something to consider further.
Come to Mr Moulton and then Mr Kells. Thank you.
Thank you. Obviously, the windfall figure of 120 is based off historic data. Previously in the plan, they looked at sites under 5 for small. They've increased it to the definition of a major application. Understand that. Obviously, that's 120 over the 13 years, 3,600 dwellings. None of those houses have any requirements for affordable housing. So, you know, there's a large supply there which won't attract or deliver affordable housing. What I'm quite interested in is historical figure says 120, but it is that future supply. So is there, you know, there's reference to stalled sites, or has there been any urban capacity work to identify what a reasonable assumption for future delivery would be?
Thank you. Mr Kells.
Yes, Gerald Kells from CPRE. In terms of the small sites, we think the approach is correct. There is no other way of knowing these sites will come forward because they are windfall sites by definition. So the idea that they will dry up has been said for the last 10, 15 years, and they never do. So that is the only basis we have. Given that that's the basis, we think they should be simply taking the figure that they have of 126. There's no rationale to reducing it to 120. That's just the figure that there is. No other reason to change it. That makes a minor difference of 84 houses over the period. Quite correct, obviously, to discount the ones that are already in the system. Before I just come on to major windfalls, there is a wider point which goes also to what we've said about density and our belief that there should be a density policy. One of the things that we should be seeking to achieve is a more sustainable situation. I wouldn't say Telford is the densest of developed town centres, and as development comes forward, some of which we know about, some of which we don't, we think Telford Council should be encouraging increased amounts of housing within town centres and in the centre of Telford if it comes forward, because that would be more sustainable. It would have access to Telford railway station, buses and all the other things that would make Telford a more sustainable location. So there is a general point behind what we say about densities and also windfall, but it also affects windfall provision that shouldn't be lost beyond the actual figures. When it comes to the major windfall sites, we don't really have any justification for why they haven't been excluded, except for the general statement, which we paragraph 519 of the housing topic paper, which repeats, it could be a mantra, that basically says they're irregular and we don't know when they'll come, which is the definition of a windfall. And if that approach is all that needs to be said about major windfalls, it applies to every single local authority in the country. And the definition in the MPPF should be changed, because the definition of in the MPPF does not make any distinction between small and large windfalls. So it is important to do more, in our view, than simply say, well, we don't know they're happening. There is also the problem that even if a local authority does have some places that it knows may come forward, if it puts those forward at an examination like this, people will, seen it happen, will pile in and say, well, you don't know this will happen, you don't know that, you don't know the other. So there is no way of doing more than looking at what evidence there is. And we say there are two bits of evidence. The first one is the historic rate, and they've delivered 570 per year. A very significant amount of major windfalls. And then is there any other evidence? And the one particular piece of evidence is the employment land, where there is an assumption, we'll slightly come back to this afternoon, there is an assumption that they will replace employment land because it becomes redundant. If it's not becoming redundant, it will come back into the employment land supply of a different building. If it needs to be replaced for a more modern building and it's going back into employment use, it will be recycled into the employment land supply. So we have looked at that and considered how could you make a reasonable assumption, which is all we can do with windfalls. And if you took the 52.8 hectares of employment period that they assume will be lost over the planned period, we've said, well, just take half of that to become houses, then that supplies something in the order of 800 additional homes. That's the basic level. If you took a figure roughly halfway between that and half what they have delivered, so still a very conservative delivery, you would deliver, so half would be about 4,000. So about half of that would be, between that and the employment land, you'd get to about 2,000. So it seems to me that there is a strong reason to believe that over the planned period, a figure of 2,000 would be a reasonable, supported by both quantitative and qualitative evidence, would be a reasonable basis for major applications coming forward. And remember, that's going forward another 14 years. So we have the opportunity for things to happen that are beyond our understanding. We know that, especially towards the period that we're in now, in the current plan, Telford is over-providing in terms of its housing numbers. We don't have an assessment that says how much of that has come through larger developments coming forward as the plan progresses, but clearly that is one element. So that's what we put forward in our evidence. And the caveat to all that is that we have done that based on what we know, which is limited, being a small charity, as compared to the position that Telford and Wrekin are in, who could look at this in some more detail, who could look at the potential for housing sites to come forward from their employment land, which becomes redundant, who could do more technical work which would give a more robust figure, and whether the likelihood is that other sites will come forward in terms of perhaps mixed developments replacing current large retail developments. You could have a more nuanced and more attempt, but that hasn't been done. All that's been done is they have simply been discounted on the basis of a very generalised approach which could be applied to any local authority. So in our view, there should be large windfalls. We think 2,000 is a justified figure. That then feeds back into additional supply which could assist in meeting the need of other local authorities, which is why the two things that we've said this morning are related. But even if that isn't the exact figure, we think it's in the hands of Telford and Wrekin, who are in a better position than us, to justify a figure for larger windfalls, which is based on evidence rather than simply the statement that they have made. Thank you.
Thank you, Mr. Kells. I mean, Councillor, you've already explained briefly why you've not made any allowance for large windfalls because of the up and down nature of the contribution, and I'm looking at figure 5 of your housing delivery paper, which shows that. But is there anything that you would like to say in response to the points that Mr. Kells has made about that major windfalls should be there should be some provision for major windfalls in housing calculation?
So the approach we've taken is therefore one of conservatism. It's to ensure that the figures that we're relying on for the purposes of this plan are robust. It doesn't mean that in due course the council will oppose windfall applications that are deemed to be major ones if they come forward in accordance with the development management policies of the plan and are acceptable. Then, you know, we're not against that. Or what we're doing in this exercise is seeking to be as robust as possible in providing reassurance that we can meet our needs, and that's why we've taken the approach we've taken.
Can I just turn to the issue of your lapse rate, your lapse allowance, and just to explain to us, I mean, it's a very small rate. Just explain why you've arrived at that rate. What's the basis for that? Why is it justified for that rate? Yeah, I think it only applies to small sites.
Thank you. Yes, that's correct. So the justification for it is most clearly set out in paragraph 4.12 onwards of document TW11, which is the housing delivery topic paper. And as you've pointed out there, a 10% lapse allowance which has been applied to small sites, defined as those which are fewer than 10 dwellings, sites with planning permission that have not yet commenced. A precedent for this has been set in a number of other authorities, for example, South Kesteven, and those are outlined in the topic paper as well. The allowance, it is sort of narrowly and proportionately applied, so it's not applied to sites that are under construction, nor to major sites where deliverability has been addressed through the lead-in times and the build-out rate assumptions. Those are the ones, so we think that where it has been applied is where the non-implementation risk is most likely to arise, and it also reflects the Council's strong delivery performance that's already been mentioned. I think we've also set out in paragraph 4.17 of the topic paper that that 10% allowance would be kept under review through the AMR and adjusted in in further future updates if local monitoring demonstrates that there was a materially different non-implementation rate for those small sites. Yeah, thank you.
Thank you. I was going to turn to Boningale because you've made this point, Mr. Moulton.
I think it's just that the lapse rate has only been applied to minor sites, and 10% is very much on the lower end of the threshold. So is that correct? Is that fair? Is that, you know? And I understand what you're saying about AMR and monitoring, but I suppose it's what triggers a change in the lapse rate. Is it, you know, does your evidence show 15%, 12% when you start applying it to your monitoring and housing land supply calculation? And then obviously, you know, there's nothing put in for any major site or any allocation. I understand that that's because you're basing it on your leading rates, delivery rates. So I suppose that's an argument for later, discussion for later in the week. So I think it's just referencing the point on minor and lapses very low.
Just very briefly, sir, just to give some reassurance on this point, if we increased the lapse rate for minor sites to 15%, that would make a difference of 10 units. So it's not a particularly consequential point in that regard.
Okay, thank you. If we just turn to, just run through the some of the questions that relate to policy policy S4, which is the housing delivery strategy policy, which is what we're looking at. We asked a question about should the sustainable communities are they so fundamental to the housing delivery strategy that they should be referred to in Policy S4? And I think the Council, you think that's the case.
Yes, as set out in our response on this MIQ, we think that's a sensible suggestion, and that's something we'll do. So perhaps I'll ask the current occupant of the naughty seat to add that to the Council's to-do list to actually provide a form of wording in that regard.
Thank you. No other points on that particular question. I know that was oh. Okay, thank you. And then if we look at question 32, which is about criterion 4 of the strategic policy 4, policy strategic 4. I keep calling it strategic policy 4, not policy strategic 4. Is there any reason why it's called policy strategic 4?
I don't know, sir, but I've done the same thing. You naturally go to strategic policy 4, but I don't think it's of any consequence.
Can you just explain to us what I think I understand how that what you're trying to do, but there were some concerns from us about the way in which it might operate, particularly the issue about likely to fall below an adequate supply of deliverable sites, council proactively seeking to increase the delivery of sites for the planning process. I just wonder whether you're able to explain the justification for paragraph criterion 4. I know you're intending to make some changes, I think, to that in terms of applying a monitoring trigger. Is that right?
So just to deal with the intention of this policy was to put something in the local plan that in essence reflected what national policy requires in relation to doing something when housing delivery gets out of kilter with what it's supposed to be. So the way national policy, for example, deals with this at the moment is that if the HDT falls below a certain level, you then put in place an action plan to remedy the situation. The policy doesn't say exactly what national policy says because there's not really any point in just having a straight copy and paste policy in that regard, but it was just to give some local plan backing to such an approach and was intended to be drafted in a way, as I understand it, to allow for changes in national policy which might have bearing on that topic. But yes, as indicated in the response to this MIQ, we're not opposed to re-looking at the wording of this and see if it could be, I think precision is what yourselves are after in this regard as to how it would actually work.
Yeah. So, notwithstanding any points that have been made, if that is an action that you can have a look at. Ms Danneman.
To be fair to the council, this is the kind of wording more precisely defined that we ask to be included in local plans. Too many of them say we'll do a review and we'll sort it out in the new plan. So we constructively ask to most local plan examinations for wording like this to be added into plans that says if there's a problem we're going to do something before we review the plan, because that's essentially what needs to happen. So we welcome the principle of this, but as with many things in this plan, I think the thinking has been done but it hasn't been explained maybe in the supporting text, that what we mean is we've got a housing delivery action plan, or we've got a team, or we've got resources, or we prioritise processing planning applications, we have PPAs. There's all sorts of things that I imagine are behind this, but as with many things in this plan, the thinking's not as explained as it could be, and maybe the solution is more information in the supporting text once the wording of the criteria itself has been tightened up.
Ms Usman-Smith.
Thank you very much, sir. It's the do something point which I think is important. Otherwise, it's not going any further than national planning policy because that will require certain actions of the council. I think they've indicated that the fall below is around the 20% mark. The way that the policy's currently worded is likely to, so it's a prospective, anticipatory almost obligation on the council. So at what point do the council think, something is going to get down to, I mean, we would say 20% is far too low, you're in trouble. When you get there, it's much better to understand and perceive these problems earlier. And then it's the do something actions, which is the really important part. What we've said in our representations about this is the council will proactively seek to increase housing delivery on certain sites. It's a laudable ambition, but how? What does that mean? I think that's the key really, is to setting that out in the policy, or at least giving a nod to what that means and then expanding upon it in the explanatory text. But we understand the council are going to make changes and comment on that in due course.
And because we're using these monitors to charge our laptops, but they're not working. So I'll just bear with me. I've got my otherwise I'll lose everything. pull that out. Bear with me, just bear with me while I sort this out.
It's this side.
All right, so
There you go.
There's a camera on me while I'm doing this.
Maybe you can speak.
Mr. Gilbert.
Thank you, sir. We, like others in the room, support the council's attempt to do something here, and the fact that they mean to be proactive here. We've got a couple of issues with the approach taken by S4. I think in terms of monitoring, we do want to see more clarity on what that means and something more specific. But our view is that monitoring delivery is likely to be too late a thing to monitor. You're not going to give yourself enough time to actually affect the outcome. If we look at monitoring delivery versus and using planning as a tool to encourage delivery, which I think is what the council's response to your MIQs suggests, is that they're going to encourage delivery through the planning process. We've already seen from the council's evidence that the planning process is a long one, and so with perhaps a 5-year leading time or 3 or 4 year leading time to getting permissions and getting them through. I think for the council's intent to be effective, it would need to monitor particularly its bigger sites, and how far through the process. In the same way as the council do in preparation for an EIP, they set out what work's been done with developers and what certainty they have on delivery. That process should be ongoing. That monitoring of these sites coming forward, so the council can see in very good time whether or not those timescales are likely to slip, and therefore the delivery that they're predicting is going to come online when they predict it. So we think it's too late to find out that the houses aren't going to be delivered when they're not being built. We need to know earlier to do something about it. Otherwise, you've basically got the same annual monitoring process and triggers for supply dipping below 5 years that exists everywhere else. And so our second point is, once it's been properly monitored and once we've got foresight of whether delivery is going to be in line with the council's expected trajectory, we're not clear on what the council's supposedly proactive approach is actually going to yield, what actions are going to it's a promise to look at an action plan or promise to look again at planning. Our submissions, sir, were that the council should be identifying a means to bring forward further sites. If the sites they've got aren't delivering, there should be further sites that can be brought forward. So that's the point in our hearing statement.
From that, Mr. Humphries.
So we've heard what's been said today, and we've already given the indication that we're happy to re-look at this issue and whether it then results in a proposed change to the policy or the supporting text. That's something we'll consider when we're looking at this and give you a proposal in this regard.
Ms. Osborne-Smith, thank you. Thank you. Okay. Thank you very much. Question 33, which is about criteria 5C, and a number of representations have been made on this, where this deals with housing development will be supported and delivered through. This is part of your housing strategy, and then well-designed windfall development in the built-up areas on a brownfield first approach. And our question was about whether that was clear what it was meant to do and whether it was justified and how it would be applied. Would you just like to explain what is the intention around that criterion and how you expect it to be applied? What does a brownfield first approach mean? Thank you.
Well, in terms of the actual question, in terms of brownfield first approach, without meaning to kind of repeat what we've put in our hearing statement to this, what we were mean to do was by Section 11 of the NPPF was to make best use of the previously developed land. That was to reflect the national approach and policy by seeking a brownfield first approach. However, we recognised that a professional approach in some instances before suitable windfall sites could be acceptable in planning terms, and therefore in the suggested modifications, CD08, we put windfall development on suitable brownfield sites, and the council will be willing to clarify how this criterion could be applied, further to text to state preferable for windfall on brownfield sites.
Thank you. So those participants who expressed concerns about this criterion, what is your position now in respect of hearing the council putting forward a suggested modification? Does anybody wish to comment on that? Ms. Danneman.
I think it's still not clear in what the wording in the plan actually says, and I'm looking at 441 in the text, which basically says we're trying to avoid speculative development, but by definition some opportunities will be speculative. So I think what they're trying to say is we're going to work with developers to plan and for these not to be surprise applications, and it's going to be part of a pipeline of actions, and the focus will be brownfield. But if there is a greenfield opportunity that comes along, surely that would need to be looked at as well, particularly if the housing deficit was quite significant. So I think in light of the downturn in the economy, the challenges of sites coming forward, the issues around brownfield BNG in particular, which I'll come on to in the future, but it's a real challenge for brownfield sites to deliver BNG. There's going to be a new consultation on brownfield delivery because of the challenges of BNG and holding up those schemes. So although you can do brownfield first, it cannot be brownfield only, because it may be that alternative sites that are not brownfield are needed because the brownfield are not delivering, because there's a specific reason brownfield sites generally are not delivering. Again, not commenting on specific sites, but just the principle. That's the reason some of the sites may not be coming forward is because they're brownfield. And if your approach is, well, to fix that, we'll do more brownfield, that won't resolve the problem.
So I think the council, through its suggested modification, is taking out the reference to first, isn't it? So your criterion would be windfall. So part of the housing strategy would be windfall development on suitable brownfield sites.
Yes, sir, and that wouldn't then prohibit windfall on greenfield sites. They could still come forward if they complied with other relevant policies within the plan. It's just adding an additional layer of support to brownfield windfall sites.
No further points on that question. Thank you. Right, so if we go back to the point that started with Mr. Humphreys when we referred to the commitments, and if we just turn to the housing delivery sheet. So on the housing delivery sheet, we'll come back to the housing allocations tomorrow. But if we look at the commitments, and we're looking at major commitments, this is a big table. It's quite a wide table, so it's not easy to follow. But there are indeed it's hard for me to read actually the whole table. But if you look at so each site is listed, and then there is an evidence of deliverability table, a column at the end. And then when we've looked through that table, we've got questions about and what we'd want to do is go through all of the ones, particularly where you've made assumptions around 5-year supply, which are in the highlighted columns from 26, 27 to 2030, 31. And it is quite hard to read, but the deliverability information, we want to go through those sites to look at whether they are actually 5-year land supply sites in accordance with the definition. So I don't know how that is best to do that, whether you want to put some more information in relation to that column to us about that, or whether you want to go through them at an appropriate time in this forum.
Yes, sir. Well, we understand what the question is. It's in essence the same process that you would undertake in relation to the allocations, but doing it specifically in relation to the commitments. So if we could just use the lunch break to have a chat about the best way to present you with a response to that would be appreciated, and then we can then pencil in an appropriate time to within the hearing timetable to deal with that issue.
Just one point to sort of elaborate and clarify perhaps where some of the questions arise from our point of view. So in that delivery assumptions column, so this is really just a pointer about the sorts of information that it will be helpful to provide. There's several instances where it's noted developer input, sorry, struggling to read this, even with my glasses. Delivery assumptions informed by evidence provided by landowner/developer following engagement. So it's that sort of information, for example.
Understand what it is you're looking for, just to get some further guidance on that. So, for example, some of the sites are sites with full planning permission, some are outline, etc. Are you wanting to see the planning permissions, for example, in relation to that? Is that going too far?
We don't need to see the planning permissions, but we need to understand where they are.
Yeah.
And if there are agreements as to how they would deliver, then that would be helpful. But we don't need to see the planning permission. But we really just, information from developer is probably not sufficient for us to be confident that that's a 5-year supply site, for example.
Yeah. We'll go away, have a quick chat now about what the best way to present you with the relevant information you need is, and then factor in a time to do that.
The reason why we're doing it is because there's a significant number of units in these commitments that are extremely relevant to the overall housing supply position.
No, fully understand that.
Thank you. Okay, so that concludes this issue in respect of the questions that we have got today. Notwithstanding our points that we will come back to look at commitments and site allocations and the sustainable communities in due course during the future hearing sessions. So it's now 25 past 12. What would be an appropriate... have we got people... Oh, Kerry's not here. There's people coming back for a 2 o'clock session, aren't there? So we couldn't start earlier, I don't think. Are the people coming who are not here for... We'd just be able to get... But what do people think about that? If we could start earlier, would that be helpful to those people who are staying? Would we be able to go and get...
I think the relevant person we need to ask is the person who's not in the room at the moment, who's been doing a very good job of keeping track of who's coming and when they're coming.
The issue is simply, can we start at 1:30 rather than 2 o'clock, really? That's what we're looking at. So.
Okay, good afternoon, everyone. Is everyone here that we're expecting? Yes, okay, fantastic. So, yep, reopening this session to do with matter 4, issue 1, which is still on strategic policies, but this time the non-housing related strategic policies, or policies strategic. So just going to go through the questions in order, and I'll lead on most of them, but Mr. Warden will come in towards the end. So starting with question 34, which relates to policies S1 and S2. Just want to start, so some respondents have made points about whether these policies should include reference to biodiversity net gain. And actually, just on that, if I could turn to Mr. Burrow, because I think this is a point you've made. If you could briefly elaborate on what you think should be there.
Yeah, thank you. Representing Barrett Redrow. So the point which we've highlighted is that the policy wording includes a hierarchy of location, which is an approach which is followed when providing BNG. But we've noted BNG is not specifically mentioned within the policy wording. Therefore, in order to make the wording clear, we are seeking clarification whether the policy is specifically targeting BNG or a wider issue. Thank you.
Are there any other comments before I go to the council on that point in particular? Okay, so can I turn to the council? I'm aware, I think, that you have suggested a possible change of wording here. So could I ask you just to explain what it is you have in mind and how that would respond to... Oh, there is, sorry. Are you sort of with the council in this respect? Okay. Maybe if I can just come to the council first, and then I'll bring you in. Yeah, thanks. Oh, he's going to answer your question.
No, he is of the council.
Oh, I see. Oh, rather than with the council. Ah.
But I'll ask Will to jump in first. Yeah. I'll ask Will to jump in first, if that's okay.
Or if we could just, if someone's speaking who has not previously spoken, if we could just ask people to introduce who they are before they speak. But obviously, Yep.
Yeah, so not to restate the MIQ response in its entirety, but the council have put forward in CDO8 a proposed modification to point E of S1, which would clarify, it would read as following: helping to address the climate change and biodiversity crisis, and then this is the part added, by securing a net gain in biodiversity and enhancing green infrastructure. So we feel that that would sufficiently address the concerns raised regarding clarity.
And can I ask your colleague to come in as well? Was there something you wanted to add to that?
The support, can you hear me okay? Is that all right? I'm Alan Priest, I work in the ecology...
Oh, sorry, you're just introducing yourself. Yeah, go.
Work in the ecology team for the council in planning, development management. The policy is broader than BNG. It's stated in the supporting text as well as the policy itself. It includes various off-site impacts as well as direct on-site impacts. Therefore, it isn't a strict BNG policy. It's broader and more inclusive to enable flexible and appropriate development solutions to take place.
Thank you. And just as a reminder to everyone to speak up as much as possible, just so that people at the back can hear, but thank you. Can I come back to Mr. Burrow? Have you seen the suggested wording change? What's your comment on whether that addresses your point?
I have seen the requested change, and in terms of does it address the points, it certainly provides more clarification, and it's the clarification that we were seeking in relation to this. So I've got no more comments to make in relation to this.
Okay, thank you. Sorry, oh yeah. Just one further question from myself. So in policy S2, neither in the policy nor the supporting text is there a reference to the nature recovery strategy, which by nature is strategic. I just wanted a comment from yourselves about whether for clarity and therefore effectiveness, whether it would be helpful to add a reference to that in. I mean, it is referenced later in the plan, but it's obviously critical to the strategic approach in this respect.
Yeah, we think we would find that acceptable. We wouldn't have any objections to that modification.
So obviously, yeah, add that to the list. Thank you. And another question, so there's a reference here, and actually this comes up again later in the plan, but it comes up for the first time here. There's a reference to green guarantee sites. Can I just ask the council to elaborate on what they are and where they're identified?
I think we'd ask Alan to cover that.
So green guarantee sites, it's a Telford specific designation, which we put on.
Ask you just to speak up a bit.
Sorry, it's a Telford specific designation, which is put on Telford owned land. So it isn't exactly a development designation as such. It's a safeguarding designation for our own internally owned land. In terms of where they're displayed, I am unsure if they're on the policy map or not, but we can get you a copy of the map of where they are if that helps.
It's a point about clarity and therefore effectiveness, and I suppose a possible risk of confusion. I mean, there's a reference to a range of different categorisations of green space, some of which are shown on the policies map, and some aren't. These don't appear to be. I was just trying to understand, well, what's the status of a green guarantee site in policy terms, and is the plan clear in that respect? I mean, does it have? Do green guarantee sites have a particular status or a different status in policy terms in the plan, or is it more just some terminology that's sort of local to Telford that is part of language that's used to describe things in Telford?
Yes, so to confirm, green guarantee sites are an agreement between the council and the landowner that site will remain green for a set period of time.
Okay, all right. I think we may have to come back to this when we get to development management policies, but just for now, is there an explanation of what a green guarantee site is in the plan?
Just sorry, if I can just go back to your previous question, Inspector, and of the two options that you, it is the latter. Yes, that's correct. There is in the glossary a definition of green guarantee, but I'm not sure, in light of what we've just heard, it necessarily fully reflects what those sites actually are. And I don't think the intention is that it has a particular planning policy status. It is more of a terminological point, which will be familiar to those who are in Telford. So I'd suggest that we add to our action list that we go away and we look at the definition in the glossary, and I think there's probably scope within that to then address the concerns and remove any ambiguity about what they are and what their status is.
I think that would be helpful. Thank you. Thank you. Are there any other... Oh.
Sorry, just to clarify, all green guarantee sites are on land which is owned by Telford and Wrekin Council.
Thank you. Yeah, so that's possibly a point it might be helpful to add in when you think about wording. Yeah. Is there anything else in relation to the first question, question 34, which is on those first two strategic policies? No? Okay, so we'll move on to policy, the questions that relate to policy strategic S3, starting with Q35. So this question relates to evidence of need for employment land over the plan period. So the council, we had some initial questions. We had quite a few initial questions around employment land, and the council helpfully provided further information and an updated topic paper. And so TW03, I think, is the updated paper, isn't it, with the supporting data in little a. And that clarifies the position on employment land over the plan period that it's suggested would change to 2021-2041. Can I just ask the council to confirm the need figure that comes out of that analysis?
Yes, thank you. So in terms of the original employment land need figure that was set out in the publication version of the plan under policy strategic S3, that was the figure of 167 hectares over the period 2020 to 2040. And that figure is justified by evidence of employment needs that were set out in EH03, which is the EDNA Part 1 document. That figure was derived from a combination of economic forecasts, growth strategies and stakeholder engagement, through which we developed a jobs growth scenario based on an Experian forecast with a series of adjustments that were applied to create a locally specific growth scenario in terms of jobs. A number of assumptions were then applied to that jobs growth figure to convert it into an employment land need figure, which was 166.7 hectares, which was then rounded up to 167 in the publication plan. We then, as part of the work on the delivery paper, we updated that need figure to take account of the revised plan period. So in order to do that, we essentially rolled forward the growth scenario that had been prepared under EH03 to 2041. Yep. So it was a need figure from 2020 to 2041.
Okay.
And then, so that figure was 169 hectares. We then removed the completions that had been recorded for the year 2020 to 2021 to get a residual need figure for the revised plan period 2021 to 2041, which was a figure of 167.7 hectares. So the one, just to point out, I think the 169 figure that's in the submission version under S3 is slightly incorrect because that hasn't accounted for the completions between 2020 and 2021.
Right.
So it needs to be updated to 168 hectares.
Right, so the figure that is in sort of subsection 1 of S3, that will need to be updated to 168 is what you're saying?
Yeah.
Okay, all right, obviously subject to this discussion, but okay, that's helpful clarification. And sticking with your paper TW03, there's table 4 there, which breaks that figure down, as I understand it, by type of employment land, effectively by use class. And I took that to be an update or a potential update to the table that's in the plan on page 31 that's slightly confusingly called table 3, table 2. But is that correct? So that those figures effectively provide an update to that data that's in the plan?
Yes,
Okay.
yeah, that's correct.
Right. Okay, thank you. That's helpful. So can I just check, is that split intended to be prescriptive or is it an indicative breakdown? From the point of view of plan implementation and monitoring, for example?
From the point of view of monitoring, I think it would be not prescriptive. I think the figure of 169 is the figure that is being planned for across all use classes.
Okay. So would it be helpful for the plan to clarify that is an indicative split, that it's not an absolute requirement for monitoring purposes?
Yes.
Yeah, okay. I think that would be a helpful clarification. Okay. All right, thank you. So that's helpful on an update to the need figures. I'm aware there are various arguments that have been made or various points put forward in relation to that. In particular, I think CPRE. Can I ask, I think you've suggested that the requirement, the need figure for employment land should be lower, I think. Can I ask you to elaborate on your position?
Thank you, yes. And I just should say I haven't seen that updated document and I can't get it down on my computer. Okay. But I don't think it affects much of what I'm going to say, except you'll have to take that into consideration. So firstly, in terms of we're not in the prescriptive world, obviously, of housing, where we have a standard methodology. So it does rely on compiling up this figure to get to a final figure. And quite usefully, table 60 in the EDNA puts that all together so we get an idea how they've come to this figure of 167. The first point is that clearly they've looked at the 3 projections of future employment growth on labour demand. They've not taken the Oxford employment econometrics figure, which is considerably lower. A reason for that technically may be because Oxford economics have a different way of approaching demographics, so that's why they tend to come up with different figures and are quite often used by local authorities. So we get the 2 figures from Cambridge and Experian, which are 122, 140 roughly. And then we have this growth scenario. And as far as I can see it, and I will be corrected if I've got this wrong, it allows for growth in particular areas where the LEP has aspirations for growth. Now that, I think, has been brought into question in other examinations in terms of LEP aspirations, because they are precisely that, they are aspirations. And you would expect a LEP to be aspirational, that's their job. Whereas the Oxford Economics and Cambridge Economics are saying this is what we expect to happen in an economic world that we can anticipate based on evidence. The other point to make about the labour trends, and it's in table 60, is there are two elements which are particularly make quite a difference. The first one is the demand for open storage, which is based, I think, on past completions, but it's not entirely clear why that should be that figure. And more importantly, I think, is the margin of flexibility, which is 44.5 hectares. So is a very considerable part of it, which shows that inbuilt into the amount of employment land that is required in the requirement is a considerable amount of flexibility before you've even got to that requirement. Now, we don't have an objection to the fact that there is flexibility. As you know, and in my past life when we were dealing with this in the Regional Assembly, it's very important to have some flexibility in terms of attracting different companies in and being able to offer a wide range of sites. So we don't have necessarily a problem with there being some flexibility, but it is in there, and it's important to note. There's also a comparison with the completion trend, and some emphasis is put on the completion trends. Now, the completion trends are much lower. They're about 136, sorry, if you exclude the Donington site. Now, the Donington site plays a huge amount in bringing the figure up to 188.5. There would be some justification for the Donington site being included if the local authority was looking for a large regional site. It's not. There is no large 50-hectare site within the plan. I think the biggest one, we quoted 18.5, but I think it's actually just over 20 hectares, 20.7, I think, in the Regulation 19 plan. So in effect, the completions trend is heavily influenced by MOD Donington. Now, it may be that the local authority should, as it goes forward, be working with other local authorities to look at regional need for those large sites. There is the West Midlands interchange. There are other sites already within the process. So whether there is a need for that, that may be something they need to get involved in through the work that's been done at the combined authority level and so on. But it's not within this plan. So we think a better comparison in terms of completion and in terms of what the local authority is trying to do is that 136 hectare figure as compared to 167, or in the Experian case, 141. So that's what we think about how we've got to the position we are in terms of that 167. We don't think that figure is necessarily justified from the evidence that's been put before you. But then that asks the other question is because the, like in terms of supply, and I don't know whether you want me to say anything on supply.
No, let's just park supply for a minute and stick with the need figure. So,
yeah, well, I'll come back to what the supply side means when I speak later, but that would mean that there is, the supply figure should potentially be lower, and any additional supply, what's the purpose of that, would be my question.
thank you. Any other comments in relation to the employment land need figure before I go back to the council? No. I am mindful that there's another representation from Ayton Parish meeting. that has made arguments, I think, similar to what CPRE have said. So if, on that basis, if I can come back to the council and ask for comments in response to what's been said.
Yes, thank you. So just picking up on some of those points that were made there. The first in reference to table 60 in EHO3, the comments that were raised about the growth scenario and why that was chosen and whether it is justified. I know some of the comments there were raised around whether it focused on LEP aspirational growth. What I would say is that the adjustments that we made to the baseline Experian forecast in order to get to that growth scenario were made primarily in the advanced manufacturing sectors and the food manufacturing sectors as well. And that was partly based on where we knew there was investment happening, but also it was partly based on historic jobs growth that had happened in those sectors, which was significantly higher than the Experian forecast had accounted for. So we felt that the Experian forecast had underrepresented future growth within those sectors based on what we knew had been happening in the recent past and was likely to continue into the future. So there is more than just aspirational evidence has fed into that growth scenario. And then the other point around the demand for open storage figure that's been fed in there. There is a justification for that which is provided in table 50 of the EDNA document EHO3, and that's basically due to the fact that in Telford there had historically been quite a lot of open storage delivered in recent years, and typically those developments don't support a high number of jobs, so the relationship between jobs and land requirement for those uses is a bit more tenuous. So given that there is obviously a demand for those uses in Telford, we felt it was necessary to consider additional provision to the employment land in order to factor those in, where they might be providing sort of lower levels of jobs, but that land is still required. So therefore, that's where the additional adjustment of 10.7 hectares was included based on that. Thank you.
Moving on to the supply side, I'm going to really just take questions 36 and 37 together, just work through those in one go. Just again, sticking with TW03, so questions to the council. I had a query, so really this is just about getting understanding the figures first before we delve into the justification. So table 2 of TW03, just a query about the third site that's mentioned there. So there's a reference to site EC5. Now that table obviously is about Newport. Is that site in Newport? I actually wondered whether that was possibly an error and should have been a reference to another site, possibly EC3.
We'll just check that out for you.
Sure.
Yeah, I think there's a correction we need to make there, so we'll go away and have a look at that for you. It's not a problem.
Great, thanks. So, because I think that will affect the total, obviously, in terms of supply coming from those Newport allocations. So it's really just to get the figures right. I think what would be helpful is once you've worked out the correct figures, is produce, I don't know, an erratum or just an update to that paper, just so we've got the correct figures. That would be really helpful. Thanks. And another question, just sticking with the council, just in terms of the figures on employment land supply. So obviously that was just a question around the Newport sites, but more generally, obviously as well as the employment land allocations, there are obviously some mixed use allocations proposed as well. And we'll talk a bit about those and what the commercial side of those might comprise further tomorrow. But I suppose my question was the extent to which potential supply of employment land from those sites, to what extent is that factored into these calculations, and if not, should it be?
So just in terms of the mixed-use sites, we didn't factor those figures into the employment land calculations for the employment land supply. I think just to give you an example, with Telford Town Centre, it would be, you might be looking at a mixed-use residential and commercial development, which might have a ground floor retail unit with flats above, for example. So we haven't relied on that. So we've taken a conservative approach to looking at employment land supply in that regard.
I'm just sticking with possible town centre sites. I suppose there's a scenario where effectively some sort of flexible E-class space, which could be office as a main town centre use, would in principle, given the categories that you're saying make up the supply of employment land, that could in some circumstances comprise office, if I understood that correctly?
Yeah, that's correct, yeah.
And again, I mean, we'll come back to this further tomorrow, but I think it's mixed-use site 9, which I've definitely got some questions about tomorrow in terms of the type of or the nature of mixed-use development that could potentially come forward there. But that is an example, I think, of a mixed-use site that's outside of a town centre, and seems to be the sort of site that could potentially be delivering other types of employment land. So again, it was just that question: to what extent should supply from those mixed-use sites be factored into this? And I mean, you briefly touched on why not. Maybe if you could just elaborate a bit further, if the council's position is that it's not necessary to sort of factor that in, just if you could just explain a bit more why not.
I think as I said before, we've taken a more conservative approach in terms of employment land supply. I think given the town centre example, we're looking at flexibility within that area, and the policy framework that we've got within policy EC6 provides for a mix of residential and employment, or residential and commercial uses that could potentially come forward on those sites. So we've not relied on kind of E-use class in that regard. But I take the point about flexibility with the E-use classes in terms of office and employment provision, or office provision. But I think our approach would be, for Telford Town Centre in particular, it's a very market-driven centre. So having a restriction in terms of what uses would go on those sites would probably create some issues where we'd prefer it to be a bit more of a flexible approach in that regard.
The MU9 point?
That's an example of a site that could bring forward possibly commercial, such as retail provision. Supermarkets that begin with an A or an L are a good example of provision that could possibly go on sites like that. So we've allowed for a bit of flexibility within the allocations outside the town centre as well, I think.
Okay, thanks. That's helpful. I think what would be good, we talked about the need just to do if you like, a quick update to TW3 just to pick up that error. I think if we just park for now and maybe come back at the end of tomorrow to whether or not there might be a need also just to add in there, just to explain the role of the mixed-use sites in terms of the supply, depending on where we get to tomorrow, I think that might be helpful. So if that could be added to the actions list, that would be great. Thank you. Okay, so if we just stick with the subject to obviously what we've just said about some tweaks here and there potentially to the figures, but just sticking with the figures on supply as they stand in TWO3, broadly speaking. As I read it, the proposed overall supply of employment land, as set out, would exceed the identified need by about a third, I think, by about a figure of something like 62 hectares. Is that, have I read that correctly?
Yes, yeah, that's correct.
And similarly, for the Newport area in particular, there's quite a significant supply above the need identified in the Newport area as well. Is that right?
Yes, yeah, although I would just highlight that the figure in the Newport study we'd specified was a minimum figure. Yeah.
Okay, so could you, again, just sort of explain that a bit further, just elaborate on why that's the position that's being set out?
In terms of the overall supply?
Yes, in terms of the supply that's being set out in relation to the need figure and that generous headroom, if you like.
Yeah, so the plan, as you've mentioned, identifies a committed supply of 205.7 hectares, and that's summarised in paragraph 6.4 in the table that's there in document TWO3, which is the employment land delivery topic paper. The section 6 of that paper also sets out the monitoring data, which shows that there have been a total of 24.45 hectares completion since the start of the plan period. So if you remove those completions from the total plan requirement, that gives a residual employment land need figure of 143.3 for the period 2025 to 2041. So again, when you set that against the committed supply, that results in a potential surplus of 62.5 hectares. What we have set out there is that some of those sites may be delivered beyond the plan period, and also we envisage that that would assist in providing sort of choice and flexibility in the market as well. So that is the justification for those figures, really, as set out there. Gavin, did you have anything to add?
Yeah, I was just going to bring a couple of colleagues in to help support the point around our delivery track record and that choice and supply issue. There's Dawn Toy, who's our estates manager, and Dan Turner, who's our Invest Telford team leader, that can just pick up on that and provide a bit of extra context to that.
Thank you. Yeah, that'd be helpful.
Good afternoon. I'm Dawn Toy. I work for Telford and Wrekin Council in the regeneration investment.
I just ask you to speak up a bit, just if possible, or maybe as much as
I'll try. So I lead on the Telford Land Deal, which is a unique partnership agreement with Homes England, which has given the council responsibility for the marketing and disposing of all their residual land holdings in Telford. And broadly over the last 10 years, the council has taken a proactive approach with this land, using a de-risking model. So in effect, we've been removing development barriers before these sites can get to the market. And this approach has broadly covered upfront site preparation. So we've been securing planning consents and investing in key infrastructure that the businesses need. And that includes early work on highway infrastructure and securing necessary electricity supplies and, in effect, creating shovel-ready sites for immediate employment use. And just looking at a couple of stats through this approach, 35 employment sites have been brought to the market during this period and actually sold, which has covered over 110 hectares of land. We've dealt with a variety of sites in terms of size and complexity, ranging from very large developments at an industrial park called Hortonwood West. So this is a 22-hectare employment park that's been delivered entirely over the last 10 years and providing more than 34,000 square metres of employment land, which is all being developed and all occupied. To the other end of the scale, which are smaller infill plots on established sites such as Halesfield and Hortonwood. And across these locations, we've seen modern industrial units and high-tech premises and thriving business clusters developed in response to the demand that Telford has seen. And just to summarise, in total, we've managed to enable 2,500 jobs through this agreement, and we've delivered more than 209,000 square metres, or in old money, 2.25 million square feet of new employment space over this period. And our relationship with Homes England is still in place, so we're still working together and we're still delivering the remaining sites to the market.
Hi, is that loud enough? Yeah. Good.
Yep.
So my name's Dan Turner. I manage the Invest Telford team. Invest Telford, sort of dual responsibility really, in that we support Indigenous businesses to grow, but we're also the front door, if you like, for inward investment and FDI inquiries as well. And just to the point really about the track record, we've seen growth recently, particularly around advanced manufacturing, but within that subsector of defence, and it's obviously a high priority at the national level, and we're working with colleagues across the West Midlands and across the combined authority area to grow Telford's cluster, if you like, with good news recently from Rheinmetall, and that Telford is the location for their gun barrel manufacturing plant. Around 400 jobs over the next 5 years that we're working with partners to deliver. Outside of the sort of inward investment FDI world as well, we also support businesses with grow on space. We've seen examples of that recently with different dog food manufacturer consolidating their operations in Telford as well. But there's a real mix of what we deal with day to day, week to week. We've already had upwards of 10 inward investment inquiries for 2026, if I look at my CRM system, and much more in 25. So the team are busy dealing with investment inquiries continuously, really. Whilst defence is a key priority for us locally, regionally and nationally, we're also seeing sort of general advanced manufacturing inquiries coming in, and also transport and logistics and distribution as well. That's the end of my notes, really.
Okay, thank you. Can I turn to others then? Are there points that people want to make around the supply? Mr. Kells, thank you.
Thank you. As you've identified, there is considerable supply above the need. Sorry, I didn't know. So there's considerable supply above the need. We haven't looked at individual sites, so I'm not going to comment on the detail of it. But there are two simple points that we would make. The first one is that obviously with so much additional supply, when you look at sites, you may decide that a site is not suitable or should not be in the supply because there's excess supply. But assuming all these sites are acceptable, it then raises the question, should there be some allowance to meet need elsewhere. And you've already heard reference to the combined authority. And that work, as I understand, is ongoing. It's not finished. And although the authority said in their reports that they haven't received any duty to cooperate requests at this stage, it's apparent from the duty to cooperate comments that partly that reflects the state of play of other local authorities. South Staffordshire Council, it's clearly the case. Shropshire, it's clearly the case. Sandwell, I haven't seen the letter that they wrote. It didn't seem to be in that bundle. And there are other aspects to this. As we point out, Birmingham is assuming a shortfall, which will feed into that wider thing. It's not going to be directly within the boundary of Telford's immediate neighbours. So what we think should happen is, if you are happy with their supply, that it's reasonable, and if there aren't reasons that it should, and I take all those comments about flexibility, some of that should be allowed to help meet other needs if other local authorities are in a position where they need to go to Telford for assistance. So it isn't tied down so that they come to Telford and Telford say we haven't because we haven't got any spare capacity because of this. So it should be within that, and we haven't put a figure on that. I originally talked about 16.9 hectares, which was based on the figures that they gave. But it seems to be there should be some flexibility to allow for that as that comes forward for other local authorities. It may not be needed, it may not be the way to go forward. Otherwise, when we go to other examinations, that will be a way of them being able to meet the need across, because many of these sectors are regional sectors. They're not just in Telford. So that's why we put that case. Whether that is something that could be done through modification to get a specific figure into that, given where we are, I don't know. But that's our concern about the employment figures. And obviously we're thinking about what will happen in other local authorities going forward.
So just to clarify, are you suggesting that there should be something said in the plan that explains the extent to which the supply in Telford and Wrekin contributes towards need in the wider region? Is that what you're saying?
Yeah, so that I mean, already within that 169 figure, we've already got considerable flexibility before we even get to that figure, because that's inherent in the modelling of how much employment land is needed. Therefore, we think it should be an allowance that there is some flexibility, that there is some allowance in the employment land, given that supply, that there is a figure given. I mean, it would be helpful if it were the figure. It would be easier to deal with if it were the figure. But there should be some allowance that Telford may be in a position to meet, should it be asked, to meet need in other authorities for employment land.
Okay, thank you. Any other comments from anyone else before I go back to the council? No. So yes, back over to the council. I'm also mindful, I'm sorry, I can't actually read your name from here. Yeah, but I'll, Mr. Humphreys, do you want to decide what order to respond and
yes,
when?
Well, I'll ask James to jump in first, as he had his sign up.
Yeah, thank you. James Dunn, I'm the Director for Prosperity Investment at Telford and Wrekin Council, responsibility for planning and economic development. amongst other things. I suppose I put my hand up originally just to sort of reiterate really what Dan and Dawn had said, partly, and then I suppose partly to answer the question from the gentleman to my right. I think, yeah, firstly, that flexibility in terms of the sites. You know, a lot of inward investment happens in terms of reacting to demand from their supply chain, from their customers. Dan gave the example of the Rheinmetall question. You know, the idea of duty to cooperate, ultimately we're working at a national level when we're talking about some of these inward investments. You know, Rheinmetall, we're looking at sites right across the country. We went out proactively because we had a site available to promote that and promote the jobs into the borough. If we haven't got those sites, we can do that, and we can promote the jobs that we want to see to support our growth. So I think it's critical for us, as it was in the last local plan. We had a similar headroom in the last local plan adoption, and that proved, as Dawn highlighted, a number of those projects that we've delivered in that inward investment. That ability and that flexibility of sites coming forward to react to the very wide range of different inquiries we get is absolutely critical.
Okay, thank you. Anything else?
No, just one additional point, which is in relation to need from other authority areas. Nobody's asked for any contributions. That's all reflected in the relevant Statement of Common Grounds and the duty to cooperate statement.
Okay, thank you. Yeah, so again, sticking with the council, turning to paragraph 6.4 in TW03, which I think was mentioned earlier. So this is indeed the breakdown of anticipated components of employment land supply. And that suggests, I think, about a third of that supply would be from the sustainable communities, about a quarter from the 14 carried forward allocations that we've already talked about, which we'll be coming back to. But this is really a question about the wording of policy strategic S3 and about, again, clarity and therefore effectiveness and ultimately, I guess, monitoring. Now, there are some of those sources of supply, in particular the sustainable communities, I think, and I believe the carried forward allocations in this instance that aren't mentioned in S3. Other sources of supply are mentioned. So my question is why is that, and should they all be referenced for clarity, comprehensiveness, and ultimately effectiveness, and to assist with monitoring?
Yes, Madam. In relation to, so criteria 2B refers to the allocation of new employment sites as shown on the policies map. So actually with a relatively simple change of just removing the word new, you would then have the allocation of employment sites as shown on the policies map for the uses specified in Appendix B and in accordance with Policy S1. And that would include, and in essence, I'm sort of jumping the gun in relation to we've not put in yet the document that responds to the query you raised yesterday in relation to the existing allocations and how they're treated. But the simple answer is they're in the policies map, so they are actually part of the plan. So by removing the word new employment sites, you therefore are covering both the new employment sites and the existing employment sites that are rolled forward from the previous version, from the current local plan.
Yeah, I can see that makes sense. What about the sustainable communities? Because they're not employment allocations per se, are they? They are, I guess, large allocations that comprise a proportion of employment land, they're not, I think I'm right in saying, not specifically referenced there as a source of employment land supply, but they account for, I think, about a third of the anticipated supply. So would it be, in the same way, I suppose, as the question around the housing policy, would it be, what's the council's view on including a reference to that in that policy as well?
Yeah, yes, we're content that we could add I think you would do it in part 2 of that policy, just add either clarification within 2B or just a new letter which refers to those employment, or the employment part of those sites.
Thanks. So yes, that could be added to the list. Yes. Thank you. And I'm mindful, and I don't know whether anyone on this side of the table wants to come in, but I'm mindful there were some comments made about, I suppose, clarity around sources of supply within the plan. Mr. Rose, to you.
Thank you. Yeah, that was a point that we made, and it's helpful that the council have reflected or agreed to make that change to provide that clarity. I think it's important that I'd call it strategic policies that link directly through to the sustainable community policies, and that link is quite clear in terms of both in the housing, which we already talked about in policy strategic 4, but also in policy strategic 3. And it's previously, prior to the topic paper coming, it wasn't always clear what role that certainly the 2 sustainable communities I were involved in, where the employment is a much smaller element of the overarching, and I think provision of uses within those future communities. And I think it is important that that clarification is provided so that people understand going forward the connection through to the needs. And I understand from the topic paper that certainly in relation to Bratton, for example, it's more about adding that mix and vitality of uses into it. And I think that's an important clarification to provide. You know, our view in relation to both Muxton and Bratton is that those sites are sustainable in their own right, given their location and relationship to existing employment areas, but the inclusion of additional employment can, of course, enhance that further in terms of creating a sustainable community, and that's important. But there needs to be that recognition then about the E-class uses that are specifically referred to in the allocation policy, as opposed to what is wider, and the flexibility around those uses, because there's any number of ways that employment can be created within the communities that then minimise the need to travel and all of those good principles. So I think without that lack of clarity, when you come to the point of determining planning applications, it could create some issues in terms of what's expected, or a misunderstanding of what's expected and what's actually being delivered and able to be delivered. So it's really important that there's a clear link, as you suggested, between the strategic policies and the allocation policies, so everybody knows what's expected, and it provides a certainty for my clients, and also we can assess then how best to deliver that within the master planning for those sites.
Okay, thank you. I mean, we will, I expect, come back to that sort of flexibility point when we talk about specific allocations and indeed the sustainable communities. Just on the, helpful to flag it now. Just on the point about the clarity in this section, is there anything more specific other than what's been spoken about already that you would be looking for in this section?
Yeah, so I think there needs to be a specific reference to the statement which the council agreed to, but I think perhaps in the explanatory text it's to set out somewhat how those communities are contributing to the overall employment needs, and what role are they intending to meet within addressing the overarching needs, because it's quite different, isn't it, to allocating a specific employment site for your traditional, what was, B2 or B8 or something like that. So there's a nuance there in terms of what's appropriate for sustainable communities and provision within them, and how does that meet then the overarching portfolio of employment uses that you expect to deliver as part of the growth of Telford.
Thank you. Any other points around this on this side? No, by the looks of it. Okay. Come back to the council. So yeah, if I could just hear your response to that. But actually, before you do, I mean, it did occur to me. Well, there's two things really. One is that that supporting text paragraph 434. Now, I think sort of figures have somewhat moved on in light of the helpful topic paper, but certainly that was flagged by a few people, and I was slightly scratching my head as well at quite what those figures related to. So I wonder whether the council could consider the need to update that paragraph. And in light of what Mr. Rose has said, I don't know what comment you might have on whether there could be any merit in some further explanation. I mean, I suppose that there's a breakdown there in the topic paper of the sources of supply, but to what extent some of that information might be helpful within this part of the plan, just to have that read across.
Happy to consider that. We'll start with looking at the text of policy S3 itself and then decide what is the appropriate thing to add there, and then in light of that consider whether we need to add anything additional to the supporting text to add further clarity to what the roles of those sustainable communities are. But we'll consider all of that and get back to you with some proposals.
Thanks, and also then to look at the figures in 434, which I think are a bit out of kilter. They don't seem to kind of quite relate to, yeah, okay.
Yeah, we'll do that, and I think that's one of those, I think that...
it's a final sweep question, issue, yes.
Exactly, yeah, I think there's a few of those.
Yeah, no, fair point, yeah, okay, thank you. That brings us on to question 39. So we're still dealing with policy S3 here. But this broadens things out a little bit. So our question here was to do with whether this strategic policy, which is, the title of which is Economic Delivery Strategy, so it suggests it's beyond just a sort of narrower employment land strategy. And bearing in mind the various priorities and objectives that we talked about yesterday, which do indeed refer to things like town centre renewal and other economic sectors, leisure, tourism is mentioned, rural diversification. The question really was the extent, should policy, for it to be a fully comprehensive and effective strategic policy, should it also be reflecting other aspects of the plan's economic delivery strategy beyond just that sort of employment land need and supply point?
Yeah, I think the purpose of the policy is obviously strategic, so it does pick up the employment land supply points. I think in terms of those other aspects of employment land delivery and employment delivery, they are covered in the policies further down the plan, so development management policies. So it could be that we could consider putting some additional supporting text to the policy just to clarify where some of those links are, if that would help.
Yes, I mean, I suppose it's really just reflecting on the role of a strategic policy and for it to be sort of setting the strategy, the overarching strategy from which the development management policies flow. Really, just whether there are some omissions, that you've got stuff in your overall strategy and priorities, and it's there in the development management policies, but it's somehow missing from the strategic policy, which is the key. So supporting text, yes, but should something actually be in the wording of the policy?
Yeah, I think what the thing to do here is to review the two bits you've referred to. So look back at the objectives and the priorities, look at the specific development management policies which relate to, so for example, policy E6, which deals with the Telford Town Centre, retail and leisure. Then we've got other policies that deal with tourism, And amongst those development management policies, you have the delivery of an economic strategy, and we can look if there is some way to tweak policy S3, which just gives that acknowledgement that the economic strategy is broader than simply big employment sites. There is other elements that go into that mix. So we can.
I think that would be helpful, and I think that would be helpful for the effectiveness of the plan. Thank you. So that brings us on to question 38, which is a question around the consistency of the plan, the consistency of the plan with NPPF paragraph 90 in terms of town centres. Now, this is definitely something we're going to be coming back to in terms of development management policies. I'm also mindful that there were particular comments from one representative in particular, so the Telford Trustees Limited, who aren't here today but will be here at a subsequent session. They've made various points about the extent to which health check data, so town centre health check data for Telford Town Centre is up to date, is a point they've raised. They've talked about, baseline assessments and therefore the effectiveness. I think it ultimately goes to the effectiveness of some of the development management policies, which is why it makes sense to talk about it then probably, but they raised it in relation to this as well, which is why I'm flagging it now. As you'll have seen, they've also prepared, or they've submitted some evidence in that regard and made an offer to the council around collating further health check data. So really, I think the action for now for the council would be, rather than sort of getting into this now, but with the benefit of their presence at the subsequent session, which will be in the 3rd week. So I think it's matters 6.2 and potentially even matter 7.1. If I could just, which I'm sure you would have done anyway, but if I could just ask the council to consider what they've said and sort of come prepared in relation to the data they've presented and indeed their offer of assistance in that regard. So it's really something to come back to. So I don't propose to sort of delve into that further here or really ask to hear from you on that now, but just flag it as something that we'll come back to. So unless there's anything else in relation to policy S3, which I don't think there is, unless there's anything else the council does want to say in relation to S3 at this stage, all that. No.
No.
Okay. All right. In which case, I think we're okay for time, so we'll keep going. So move on to question 40 in that case, which brings us on to policy strategic S5. Which is to do with mitigating and adapting to climate change. And again, here as well, we've got a situation where we need to stay focused on a strategic policy and not get too, I think, drawn into the detail, which we will inevitably come back to in terms of the development management policies that sit under it. Again, I'm mindful that some of the comments made in relation to this point do sort of overlap with some of those detailed points around building regulations and viability, which I think are matters that it would be more sensible to deal with in the DM session. So with that in mind, and also sort of bearing in mind what NPPF paragraph 21 says about the role of strategic policies, are there comments? I think there were comments, in particular, I think, from David Wilson Holmes. I don't know if there's anything that you wanted to say in particular in terms of I mean, you had made comments in relation to this policy. Is there something you'd like to sort of elaborate on at this point, keeping it at that strategic level?
Thank you, Inspector. Simon Hawley from Harris Land Planning for David Wilson Holmes. Not a significant amount to what's in our hearing statement. It's points of clarity really in how the policy will function in practice. So, for example, it refers to meeting local and national targets. Well, which targets exactly? It's not clear from the policy which they are, and by positively contribute, does that mean you have to meet them, get towards them, exceed them? It's just a language point really, so when it's being applied in practice, what's expected of the developers? Also, in terms of aspects of a policy, I'm mindful of what you've just said. There would appear to be a degree of duplication between sections of this policy and what's required elsewhere. So, for example, Part 2A refers to the need for travel and sustainable modes of transport. Well, is that required, or does it duplicate what's required in policy ST1, which is the sustainable travel policy? So it's just a relationship of this policy to other sections of the plan as well.
And Mr. Burrow.
Thank you. I mean, the key comment we wish to flag is in relation to point 4 of the policy, where the wording at publication stage talks about development achieving net zero, and it was really a point of clarification about whether the intention of that is for buildings to be net zero or to contribute towards achieving net zero.
Okay, thank you. I mean, I also had some questions around part 4. So if I throw them into the mix, and then I can ask you to come back on all of those points, and they're interrelated. I'm also mindful I think that the Council has suggested some wording changes already, so I'll ask you to talk about those. Yeah, so in relation to part 4 in particular, it talks about measurably, so demonstrate how the development will positively and measurably contribute. So my question to add to those was, what's that referring to? And also, what is the rationale for the types of application requiring a sustainability statement, in paragraph 448. And this is, again, something I think we're going to need to come back to when we talk about the development management policies that flow from this strategic policy. But how, because that's actually, I guess, fairly detailed already at this stage, how that fits with the other application requirements. So again, this might be a question to think about and come back to, how that fits with the other application requirements set out in Chapter 6 and 7 in relation to the various documents or supporting statements, supporting evidence that would be expected to come with an application in relation to various aspects of sustainability. Well, in the sort of narrower sense here. So therefore, if I could ask the Council to explain its thinking, explain your thinking around the approach with the sustainability statements and part 4 of the policy in particular. If you could also address those sort of language points that have been raised, including the point about measurably, and then wrapping into that, I suppose, talk about the wording change you've already suggested and how you think that might assist.
Yes, if I deal with the language points, if I call them, so yes, the change we've already suggested is in relation to 4, is to add the words contributing to achieving net zero, so that to make it clear that it's not a requirement that every development that comes forward must achieve net zero. Net zero is a wider, national objective, and development should seek to assist in achieving that objective, but that doesn't mean that every development in and of itself must be a net zero development. So we've proposed that amended wording there, and we think that sort of adds the adds sufficient clarity there. In relation to the use of the word measurably, the rationale for having such a word in a policy like this is because it's quite difficult for councils, when they're considering applications, to form a view on whether or not something is doing what it needs to do with regards to net zero, climate change, etc., in the absence of a metric. You need to have something that you can point to say, well, if I judge it by this standard, this set of criteria, this guidance document, these units, there is a measurable change. And so introducing the word measurably allows councils to actually say to applicants, prove to us that this is doing what it needs to do in that regard. On the sort of wider points about the language used in policy strategic S5, not strategic policy S5, from our perspective, the words used are appropriate for a strategic policy, and you obviously then have that sits underneath this specific development management policies, which have very specific requirements within them. And when you're assessing any given application, you would assess them against the compliance with the development plan as a whole. So we're comfortable with the wording that's put forward for the purposes of what this policy needs to do, which is a strategic one to provide broad guidance on development. In terms of then the question as to the thresholds, as it were, for when sustainable statements needs to be used, if I could just look to
Just ask you to just introduce yourself as well. Thank you.
Sorry, Ian Wykes. I manage the climate change sustainability team at the council. The thresholds are set out in 4.50 about all new build and non-residential developments over 1,000 square metres. If I may, just make a general point, which I think talks to some of the concerns raised. Policy S5 is very, very broad, and sustainability by definition is a very broad topic, and I think it's important from a strategic policy perspective to look at things in the round. And our point around sustainability statements is this is the opportunity to allow us to consider MPPF requirements, chapter 162 going forward, about a proactive approach to managing climate change. So it may feel there is replication, but obviously a lot of different aspects feed into this policy. So for something to be sustainable, it would be to do with layout, EV charging, building regs would come in there as well. Obviously building regs is around compliance rather than aspiration in the sense of what this policy is trying to achieve. So for us, building regulations on its own would not achieve necessarily the aspirations of MPPF or what this policy is trying to set out. So I think it's important to demarcate, to say that S5 is very much around that strategic role before you get into, as you say, the devil's in the detail in section 6, which is more the development policies. And then that, I think one of the comments was around, so what are the targets? And they are set out in section 6 about the government, the Climate Change Act targets, the council's own targets as well. So I think S5, for me, the spirit of it is much more around that more strategic view.
Okay, thank you. I think that probably reinforces for me the fact that it because of the interplay between particularly this reference to sustainability statements and the more detailed requirements which in and of themselves will need to be looked at, that sit in some of the related development management policies. I think the particular point around sustainability statements is something we may need to come back to when we are in that DM session, just to, again, make sure that there is a clear read across around the requirements to avoid any ambiguity or confusion. I think there possibly is scope for that because because of that requirement there and various other things in the other part of the plan. So we'll come back to that. Can I just ask, it was Mr. Hawley and Mr. Burrow, whether what you've heard around the language points, to what extent that addresses your points. If I start with Mr. Hawley, and I think there was the particular wording changed, and I'll ask you what you think about that.
Yes, thank you, Inspector. It does. It was not a point we were particularly precious about, but providing, in fact, having plans designed to work, we're comfortable in that context.
Okay. Thank you.
The proposed wording change does address our comments.
Okay, all right. Well, that's helpful. Thanks. So, yes, in which case I think it's best to leave it there, but with the note to ourselves that we will come back to that sustainability statements point. So it's not impossible that we might need to revisit aspects of this wording when we come back to that at a later point. Okay. Yeah, I think we're still okay. So that brings us on to question 41, Policy Strategic S6. And here, I note the Council has given an explanation in relation to criterion F, which is helpful. And I also noted that I think you have made some suggested changes already in CDO7. It's CDO7, isn't it, which is the list of suggested changes. I just made a note here around the ones that you've currently got labelled as MOD 26 and 27. So it's really just to note those. They certainly appear helpful in dealing with some points that had been raised in representations. Is there anything you wanted to add about those at all?
Not unless there was a particular question.
No. So I think in that regard, unless... so we have got a question. Mr. Crampton.
Sorry, Joseph Cramphorn Savills on behalf...
Sorry, Cramphorn.
That's okay. It's distance. On behalf of Defence Infrastructure Organisation.
Yep.
My point was actually in relation to S5. I just didn't get
apologies.
On the previous round, but I came in quite late, so I wanted to let the sustainability discussion go through and run its course, because I'm separate to that, but related. In terms of the point at 3E...
So, sorry, you're talking about S5 now?
S5, yes.
Okay.
It was just on 3E.
Okay, well, I'll tell you what.
Come back on that, just to put a marker down, to come back to it whenever it's...
Yeah. So I'll just very quickly finish on S6. So can I just check, is there anything anyone wants to say in relation to S6? No. Okay. So I have no further questions on S6. So in which case, yes, apologies if I missed you. I didn't see the thing up. So but coming back to S5, yeah.
Yeah. Okay, thank you. So it was just a point on 3E. So there is reference to a modification there to include the setting of heritage assets. And I think we should be mindful that when considering significance of heritage assets, it's the setting and the relevance of the setting depends on where what the heritage asset draws its significance from. So setting is not always necessarily of the most relevant or indeed relevant at all in terms of assessing the protection and sort of harm to heritage assets. So I wonder whether it would be potentially more helpful when we're referring to setting for it to be setting where relevant rather than a broad brush approach to considering setting of heritage assets across the board. And that was the only point on S5.
And can I just clarify, is that a point you're making about a modification that's already been suggested?
Yes. So that's in the highlighted yellow text. text, the modified.
Right, yes, because of course remember we're examining the plan as published in this case.
Yes.
We're having regard to some possible suggested changes.
Yeah.
Just turn to the council just on that point.
Yes, Madam. Heritage assets and their settings, obviously something that has been subject of extensive litigation. The statutory duty differs between conservation areas and listed buildings. So for listed buildings, there is a statutory obligation to preserve settings, whereas there's not for conservation areas. But then national planning policy tells us that what matters is the contribution setting makes the significance. The suggestion that has been made in terms of a modification to the modification that we've proposed, we wouldn't find objectionable in any way in light of that. But then whether or not, I mean, I think even if you look at the original submission version of the plan, balances the need to protect and conserve historic assets, I think is broad enough to encompass the setting anyway in terms of the contribution that would make to the significance of those heritage assets. So I think the question in the first instance for yourselves is whether you consider the modification that we've proposed is necessary. If you do consider that that modification is necessary, we'd certainly be content with the additional modification to that modification that's been suggested to add where relevant.
Thank you. We will take all that into account and consider it. Okay, so that's no further questions on question 41 if there's nothing else. At which point, so yes, at which point we'll have a break now and then reconvene, and it will be back over to Inspector Ward on the final question. Oh, so we'll come back in 20 minutes?
Yeah, 3:15.
3:15.
Yeah, that's what. Yeah. Is it Wappenshaw or Wappensall? I'm pronouncing Wappenshaw. Yeah, Wappenshaw. With a sh. Yeah. Yeah, shush. Yeah, my name, you've come across me before, so you remember from was it the Broads plan or Norfolk? Norwich, that's it. Yeah. Keep you busy. Yeah, but yeah, it's been a few sections of the Yates this year. Planning inspector is pretty packed. Examination at the moment. Yes. Was it Norwich local plan that you did? Yeah. That went on for ages as well. I don't think this one will though, is it? Is this it's really straight. Yeah. 3 weeks. No, they haven't crammed it, have they?
Okay, thank you for coming back on time, and we're now dealing with the final question in relation to issue 2 on this matter, and this relates to policy strategic S7. And the council has helpfully produced a topic paper on this matter, which I think sets out their position But I wonder, Mr Humphreys, if you can just outline for us, just to start off with, what and the main concern, from responses is with the fourth criteria, or the final paragraph about liability clawback. And I wonder whether you could just start off and explain what it is the council are trying to achieve or seeking to achieve with this policy and that paragraph in particular, and now what you're proposing to do as a modification to address some of those concerns. Thank you.
Thank you, sir. I'll ask James to jump in on this as well. But in a nutshell, what this is proposing to do is, the starting point is an assumption as per national policy that sites are viable. And so if you're wanting to do something different to what the plan-led requirements are for the site, you would need to make a viability case. And so what this policy is seeking to deal with is the situation in which that happens. Somebody comes along and says, here's some viability evidence that demonstrates we can't do, or is used to support a case that we can't do X, Y, and Z. This policy seeks to deal with a situation in which that happens, but then when the scheme actually progresses, the position has changed and that scheme can actually provide or can make a partial provision towards the X, Y, and Z that it was previously said at the original application stage it couldn't. So it's to ensure that throughout the planning permission process, there is a mechanism to ensure that wherever possible, schemes do actually make the necessary contributions to the necessary infrastructure that they should be doing. I'll just ask James whether there's anything additional on that he wants to say.
Yeah, thank you, Freddie. Yeah, I mean, as Freddie set out, I mean, ultimately, we have always been supportive of growth, always been supportive of delivering homes, and we accept, as we have done through a wide range of planning applications that have come forward, how we've dealt with viability previously. But effectively, we want to have that, ensure that mechanism in place so that developments pay their fair share of what we expect through this plan, and therefore, hence the mechanism. I suppose just the other point to add is that in terms of other income streams, obviously we work tirelessly to secure funding from West Midlands Combined Authority and others through their brownfield funding, and so ultimately, if other funding can be secured to support development post-planning, then ultimately that releases more money into the pot to then support the obligations that we'd have originally expected when the application landed.
And so this would obviously be secured through the use of Section 106 agreements on any given application, which would make provision for the review mechanism. And by having a policy to this effect, it gives you a policy basis for including such a clause in 106 agreements, rather than having to make an argument to that effect on any given case where you think it's necessary. It provides development plan support for such an approach.
And has this arisen through a particular history in Telford and on sites where you've not managed to get clawback, you've not managed to get appropriate provisions in Section 106s, or is this something that you're anticipating could happen?
Yeah, we've had concerns raised by elected members, through schemes approved at planning committee, and then ultimately, wanting to know that that applicant has paid their fair share in terms of the policies where they can, and ultimately, with some of these sites, they are larger and take some time to come forward. Clearly, as we've acknowledged in the amendments we've made, costs move as well as values. But ultimately, it's making sure that the developer, as I say, pays their fair share. And I think members have previously raised some concerns about about that when you're presented at a certain, especially at a certain time in the economic cycle, a application where perhaps values are depressed or whatever, then ultimately that almost otherwise runs with the consent until it's built out, rather than, you know, it's more of a timing issue as much as anything.
You've clarified it, well, you're seeking to clarify it now in your suggested modification, but it would apply to major developments, 10 or more houses, allocations or not allocations across the borough where there would be a viability argument made out by a developer. It would apply to all those sites.
Yes.
And just take me through then your topic. Well, your topic paper does it, so it's very helpful. But you say that you then looked at the comments that were received at Regulation 19, and you're suggesting now modifying Part 4. Do you just want to just take me through the key elements of the modification? I've got it, and obviously it's clearly set out in that topic paper, but just take me through your thought processes in that modification, if you would.
Yeah, so effectively the modifications look to apply different levels of viability assessment depending on the scale of the developments and also the timing of that of those assessments as well. So we are saying for any strategic schemes of over 500 units, we'd undertake a viability assessment at a point of 60% of the housing units completed, where otherwise, if it was less than, between 50 and 500, it would then be done upon completion, and anything below 50, we'd look to apply a lighter touch rather than a full viability appraisal, do a lighter touch based on actuals in terms of what the gross development values delivered, as well as the construction costs at that point.
And how would you know that there would be likely to be how would you know that there was likely to be an uplift or a clawback? How would you know that?
I think in the first instance, if you took the smaller, the less than 50, for example, I think the first port of call would be to just be able to have sight of the completion, the sales completed, so which would be public record, land registry records in terms of how much each house sold for, and then ultimately from there you could compare that with the gross rent value that was in the viability assessment, and then from there you'd then approach the developer in terms of evidence of their construction costs from there.
The costs of that process will be met by the developer, and that would be set out in the Section 106?
Yes.
Can I turn to those people who've raised comments about it? So there's two sets of comments. There's comments that relate to the version in the publication plan, and then there are further comments in relation to the suggested modification from the council, and some of those are quite detailed. For example, in Wappensall's statement, the hearing statement, it's quite a detailed response, explanation of your position. But would you just like to, you've heard from the council, would you just like to tell us what your concerns are and why you think this is not a sound approach?
Thank you, sir. Well, a number of points, and they're set out in our written representation. So we'll make all the points in one go, and then there'll be an opportunity, no doubt, for others to either come back on that or add to it. Just by way of preface, so we're not addressing here the bigger issue of the overall viability of the sustainable community allocations, because that's later on in the programme, as I understand it, sort of matter 5, issue 2, question 51. So we'll come back to that. As regards this policy, sir, we have 4 points. 3 are fairly short points, and the 4th point is to do with the review mechanism, which is a slightly more involved point, where I'll hand over to Mr. Spilsbury. So as far as the 3 short points are, the first point that we have, and we've made this in our written representations, is that as we read it, we're going from the submission version now, which shows the proposed modifications. there was a reference to the SIL regulations in the policy, which is no longer clearly set out. That the contributions have to comply with SIL, the tests that we're all familiar with, necessary, proportionate, reasonably related, etc. So that's not there, and it should be there to make it. If we're going to have a policy, it should make it clear that it has any contribution sought have to be compliant with the SIL regulations. And I would submit that really that's all paragraph 1 needs to do. He doesn't really need to do anything more than that, because the question of whether any contribution sought is compliant with the SIL regulations is something that can then be addressed at the application stage. The second point is that if you are going to have this more detailed policy, then there's one thing that's in there that shouldn't be in there, and there's one thing that isn't there which should be there. So the one thing that should not be there is if you look at policy 1C, ongoing revenue via commuted sums for the management and maintenance of services and facilities. And that's far too broad. Our understanding and my understanding from having been involved in numerous applications and appeals with the SIL regulations is that it's very rare for a council to be able to justify a commuted sum for ongoing management and maintenance of services and facilities. And services and facilities is a completely unlimited category here. So if we're going to have that, it should be restricted to public open space and SUDs. That, in my experience, that's the only thing for which councils can seek a commuted sum for ongoing maintenance and services. That would be SIL compliant. Asking for, say, for example, a commuted sum for the ongoing management and maintenance of other services and facilities, whether that might, that could include anything and everything, police, NHS, etc., etc. That simply can't be right and is contrary to the SIL regulations. And in terms of what's not on the list and should be on the list as a matter of consistency is that you'll see in policy HO2, Sustainable Community 1 and Sustainable Community 2 have to pay a contribution for the provision of school for the provision of a school on SC3 in respect of land and build costs. So if we are going to have a list, it has to be complete. And at the moment, it makes no reference to land and build costs, particularly land. So that would have to be introduced into that list. And that's why I say it's better not to have a list at all. Simply have paragraph 1, which says that contributions will be sought insofar as that they are consistent with the SIL regulations, which is more or less what paragraph 1 says at the end of it. It says, subject to statutory processes and regulations, contributions may be collected towards. So why not just make it much simpler and say contributions and will be sought where they comply with the SIL regulations. So those were the 3 short points. The bigger point relates to the clawback mechanism in paragraph 4. Now, so we know that some people object to the clawback provision in principle. We remain neutral on that. We leave that for others to address and for you to make a decision on. What our representations have done is to concentrate on saying, well, if you are going to have a review mechanism, it should be clear, it should be reasonable, and it should be consistent with national policy. And at the moment, the way it's drafted, we say that it's not. And in terms of the detail of that, if I could just hand over to Mr. Spilsbury. Thank you, sir.
Thank you. Matthew Spilsbury, Senior Director, CBRE for the Wappenshaw Consortium. As my colleague set out, our focus is on the soundness of the policy as it's set out, and really this focuses in on a matter of clarity, effectiveness of the policy, and the reason being is it needs to be consistent, in particular with paragraph 10 of the Planning Practice Guidance for Viability, which itself sets out that plans should set out the circumstances where review mechanisms may be appropriate, as well as a clear process and terms of engagement regarding how and when viability will be reassessed over the lifetime of the development. The concern that we have is that even with the modifications as proposed by the council, the policy itself and the supporting text, so this is section 4, as well as paragraph in the supporting text 4.62, does not clearly and coherently address those requirements in paragraph 10 of the planning practice guidance. Notably, there isn't a clear methodology or process. I know it was set out briefly by the council, but the topic paper doesn't go into sufficient detail to set out clearly how that process of review is undertaken. There's also introduction of what I'd refer to as ambiguous terminology, and that terminology may well risk misinterpretation, dispute at the point of either determination, a drafting of a Section 106 agreement, or even thereafter at the review process stage. And some of that terminology, taking several examples, are updated cost, normal profit, lighter touch, which was referenced again, and normal land value. That's in a combination of Part 4 and also 4.62. Now, the terminology that should be used within the policy and the supporting text should be consistent with the planning practice guidance, but also relevant RICS guidance and professional standards as well for this, that govern this area. There's also reference in 4.62 in respect of the analysis of costs, where it refers to a review against construction prices index. That's not a recognised index to my knowledge, and not one that we would see typically referred to in viability review mechanisms or Section 106 agreements generally for a purpose of indexation. That should be the standard approach to utilise the RICS BCIS all-in tender price index. And again, that lack of specificity will give rise to potential conflict and debate subsequently. The next point is that when I mention methodology, one of the key areas is to understand how, or a developer wants to understand when entering into a review mechanism and then undertaking it, how the council is going to deal with matters of revenue and cost, particularly on larger schemes where the review mechanism as proposed is going to be undertaken before a scheme is actually completed. So the proposal is at 60% on schemes of over 500 units. Now, there's a lot of development still to occur, a lot of sales still to occur on a residential scheme at that point, and it therefore needs to be very clear that it would be based on actual information up to the point at which the review is undertaken, and then forecast information thereafter. So there's some very clear points of methodology that need to be integrated into this. The point about the Section 106 agreement, which was raised by Mr. Humphreys, agree with that. I think it should be referenced actually within the policy or supporting text that it would be agreed by way of a Section 106 agreement, so there's absolute clarity there. The final point I want to raise is in relation to the actual trigger timing. So, as was referenced by the council, smaller schemes of less than 500 units would be reviewed when 60% of the scheme is completed. When 100% of the scheme is completed, but larger schemes, the review would happen, as I said before, at 60% of completions. That in itself is quite early for what is effectively a late stage review. What we would typically see, and you can look to examples where this is sort of well established, such as the London Plan, would be for a late stage review to be at circa 75% of the way through a scheme, such that there's more certainty, particularly on larger schemes, as to the level of construction costs, the level of revenues that have been achieved to that date. It's therefore logical that there's some consistency there with well-established practice. The second point that I want to raise is quite fundamental in relation to that trigger, is quite a fundamental one. And where we see national precedent to date of review mechanisms being put in place by local authorities, typically where it's a late stage review such as this, and the risk of that review and the incursion of additional cost and time is recognised as being carried by the developer until the point of that review and that matter is discharged, that there is usually what we refer to as a sharing of any surplus between the parties. So if you look to the London plan, or if you look to locations such as Manchester and other regional cities where review mechanisms are more established, what you would see is typically to incentivise the developer to seek to outperform and create a surplus, to create let's call it a super profit, such that that money could be put back to the council to contribute towards meeting those obligations which were set aside at the determination from a flexibility perspective through the original viability assessment. In a clawback approach, typically any returns are shared up to the point of which there is a policy compliant sum paid through the review process. So what we typically see is that being either, it's typically up to 50-50. And in some cases it's higher than 50-50. So at the moment, for example, with some of the emergency measures that have been or are being introduced and some of the changes that have already been introduced by the GLA in London, in certain circumstances, the developer receives up to 70% of any surplus, with 30% going to the local authority. That might not be appropriate here, but certainly it would be logical to look to a sharing of that surplus. The reason being is that it does incentivise a developer, as I said, to perform and to meet more than just their minimum hurdle. If there is all of the surplus going back to the local authority, there is no commercial incentive for the developer to outperform. They would simply do the minimum, because commercially, why would you go over and above when there's no benefit to do so? So that's why the GLA and other local authorities have taken hold of that logic and said, well, actually, we need to give a commercial incentive, because otherwise we might well not get anything. It's better to get a shared sum than to not get anything at all through the review mechanism process. So what we've set out within our hearing statement, so it's document M4.02, and it's pursuant to paragraph 2.17 on page 4 to 5. We've actually proposed a full rewrite of part 4 of S7, which we consider addresses those matters of soundness that I've set out. In doing so, this has also allowed for a simplification of the council's reasoned justification set out in paragraph 4.62 within the plan itself, the draft plan. The idea being that that means that it's a clearer justification. It's also consistent as well with part 4 of the policy. Thank you.
Thank you, Mr. Spilsbury. Just to check on that, so clarify for me on the issue you talked about the 50-50 split, the surplus. So that would be on any surplus, even if there was still not policy compliant. It's not, it would all go back to make the scheme policy compliant, and then anything above would be 50-50. It's 50-50 from the clawback position. Is that correct?
That's correct. So it would be 50-50 through the clawback provision until the point at which that 50% that's going back to the council had met the entire policy obligation.
And then there's no surplus.
And if there's any surplus left over beyond that, then that would go back to the developer.
And is that legal?
I believe so, because albeit I'm obviously not a legal professional. However, it has been set out in numerous Section 106 agreements, and I strongly suspect, albeit I haven't got example to hand, that it will have been tested through both the appeal and I suspect through the legal process as well in relation to examples of projects in a London context.
I was simply going to add, I've not seen it in a plan, but I've seen it in Section 106's, the 50-50 provision, and to my knowledge it's not being challenged, so there's no High Court case which will tell you, yes, this is lawful. I've seen it in 106's, I've not seen it in any adopted plan. Hasn't done none of the Salisbury has. But even if it's in an adopted plan, unless the plan is challenged, you're not going to get a legal ruling as to whether it's lawful, unless until it's challenged, challenge either upheld or quashed.
And where you've seen those schemes before, those arrangements before, they've not been within the policy, they've been within the Section 106.
That's right, I've seen it in Section 106 agreements. So I was involved one in rugby recently, and that was a Section 106 agreement that we agreed with the council that there'd be a second stage review, and any surplus would be split between us 50-50. I mean, that was where we eventually got to. There was a lot of horse trading about what it would be, as you can imagine, in a 106. So
does the need for policy need to serve as a hook for the detailed arrangements to be set out in a Section 106?
I suppose the only benefit of having it in the policy is that you would avoid all the horse trading that we had when I was representing the developer at Rugby. We were saying we'd give you 30%, and they said no, we want 75%, and there was a lot of toing and froing because there's nothing in the plan as to how any surplus should be split. If you have it in the plan, it just avoids, it makes the Section 106 agreement process quicker.
That's the exact reason why it's better to have it within the plan, because you avoid then ambiguity and dispute at the point of determination or the point of drafting the Section 106 agreement. It provides absolute clarity to all parties involved as to the terms and the risk, which is why it was brought into the London plan. So it's actually in the GLA's Affordable Housing SPG document. So it sets a basis for every project. There are variances because it's complex in that, or more complex in that environment, but it's very clear how it applies to all projects that are brought forward in accordance with the London plan. And I believe it's my own personal opinion, professional opinion, but I believe that's the intention going forward of government, to seek to have more clarity in policy to try and avoid disputes around particular schemes in this matter going forward.
Thank you. Mr. Rose.
Thank you. Yeah, very grateful to Mr. Spilsbury for setting that out very clearly. It's the exact point that my client wanted me to make to you today. We've sort of set out some concerns around the principle of using this review mechanism, but we recognise what's in the PPG. I suppose the only point I would also add is that the review can highlight that, that in terms of the viability, it can swing both ways, ultimately, that it might not be a clawback arrangement that we're looking at, but an alternative where the costs or the viability is actually squeezed as later stages as development goes on, depending on where it comes in the economic cycle. So just to add that bit extra to it. I also wanted to agree with the three small points that Mr. Chung raised as well in terms of the policy drafting itself, except I don't, with respect, agree with his conclusion in terms of a simpler policy would be better, because I think a lot of what we've been talking about today has been around clarity and certainty, and the interaction between the strategic policies and the policies that follow on from them, whether they be the development management policies or the sustainable community policies. And a particular concern that we have, and it stems from our experience of delivering similarly sized, complex, sustainable community schemes around the country, is in relation to infrastructure delivery generally, and how you create the framework for that and facilitate that. And goes to the point that Mr. Chung was making about removing that uncertainty at the development management process or stage to ensure that actually the schemes can move through that process as swiftly as they can without further delay, and result in the delivery and ultimately the delivery of the infrastructure where we want them, when and where it's needed. And in that respect, respectfully to the council, I don't think the strategic policy strategic 6 and the policies that follow provide that framework to allow that to happen. There's a dispute, a question of whether it should be in the strategic policy or it should be in the individual policies. It's probably a bit of both, but when read as a whole, it doesn't provide that clarity at this point in time. And I think some of the complexities come from the nature of those schemes that are large. They have multiple land ownerships within them. Actually, some of them are a collection of sites within an allocation rather than, and you'll see that for yourselves when if you haven't already been to visit some of them. And that's going to be reflected in the way that they come forward, that there will be naturally, I think, a number of applications within each of the allocation sites. And then how do you deal with that question of where the infrastructure is provided, how that's funded, and the land question that Mr. Chung raised in particular, I think, is key to that and does need to be taken into account, as well as the capital costs. And we've set out in our hearing statement, both in relation to this matter and later matters, about how that can be addressed. And this is readily rectifiable. This isn't a fatal flaw in the plan at all. It's something that can be dealt with relatively easy. It just requires, I think, at this stage, some thought and some articulation through the policy and explanatory management. So everybody's got that certainty in terms of the council when it's making its decision, the stakeholders in terms of knowing what's going to come forward, and the developer in terms of understanding what's expected of them and when it should be provided and how it should be provided too, within that context of a number of developers are likely to be delivering a number of sites within the individual allocations. And I think what we've suggested is that there's a clear role for the development briefs or design briefs that are referred to within later policies in terms of setting out the specifics of that in relation to the individual sustainable communities. But the framework needs to be established, I think, within the strategic policy in terms of setting out what's expected, the matters to be taken into account, and how that would be addressed on a fair and reasonable basis. And as I say, we've given you more detail in our hearing statements in terms of the proposal that we put forward as part of the draft development brief that we had prepared for the Bratton Sustainable Community, albeit we understand that the initial feedback we've had from a development management context is that they don't necessarily agree with the sort of roof tax approach that we'd set out that takes account of both the land and the capital costs. But there's an absence then of a suggestion of an alternative way, and that's a perfect example of how this can create a significant delay at the development management stage that we need to avoid if the housing trajectory as set out in the local plan is to be met in terms of delivering those sustainable communities. So it's a really, really important point that needs to be addressed at this stage very clearly, so everybody understands the expectations, how it can be delivered in principle, and then going forward that can be addressed in the development management stage. I think just going back to the viability point, I think in terms of our concerns that we'd raised, the principle of this clawback, I think had been largely coloured by the position in terms of the viability of the sustainable communities and the evidence in relation to that. And it really highlights, I think, the importance, as a general point leading into later discussions, really highlights the importance of understanding the likely infrastructure burden and the other policy implications that come through the other policies and scheme, notably the affordable housing, and the impact on the deliverability of the sustainable communities and ensuring that that works at the plan making stage as the PPG requires you, and it's not something that can be deferred to the DM stage when this review mechanism would inevitably kick in on the basis of the current policy requirements. The illustration being that there's a 25% affordable housing requirement currently on the sustainable communities, but the council's own evidence base says the sustainable communities it would be challenging to deliver 20%, and that doesn't take account of the more recent information that we have in terms of the education and other community school costs that need to go into that infrastructure delivery. So I think it's just to highlight, to conclude for later discussion, that there's really important that, again, that's addressed at this stage, as well as setting out the framework to how that infrastructure is going to be delivered at this stage, and not allowing that can to be kicked down the line to the planning application determination stage. That clarity is absolutely important to provide the certainty to allow my clients and others to make that investment into delivering these sites.
Thank you. Mr. Humphries.
Yes, thank you, sir. We've strayed somewhat there beyond, I think, the scope of the question in relation to policy S7, and so understand that points are made and will be made in relation to the sustainable communities and the specific requirements for them under the relevant policy. So we'll return to that at the relevant stage in the examination. But just dealing then with the specific issues in relation to S7 itself, just note that there is no challenge to the principle of a policy like S7 having a clawback provision in it, and in reality there can't be, given what the PPG tells us about the utility and appropriateness of such policies. So the question then really is, does the language of the policy do what it needs to do? We've obviously proposed a main modification in this regard ourselves, and there is not one right way to do a policy like that, like this. There are numerous ways you could draft it, which ultimately would be sound, and so the question is ultimately, have you got a sound policy before you? And we say, first of all, that the main modifications we have proposed are sound, but we're happy to relook at this in light of the representations that have been made today and those in writing. But as we sit here now, we're content that the modifications we've proposed are sound. And so just to deal really with the specifics, the revisions that are now proposed in the policy itself in criteria 4 make it clear what developments will be subject of this provision. So that is your major developments of 10 homes or more. A point in time, the requirement to review is triggered, is clear as well. Completion, if you're less than 500, if you're more than 500, 60%, that is clear now in the modification that we've proposed. Various comments were made about, well, could there be more detail about what you would have regard to when carrying out the viability assessment, for example, reference to RICS guidance, the PPG, etc., and reflecting the wording therein. There is no one-size-fits-all approach to doing viability assessments. Different consultants will have different approaches, and so we don't think there is a need to say, do very specifically this, this, and this. And actually, any relevant guidance that exists at any given point in time is something that you should have regard to. We can't be prescriptive at this stage as to what the necessary guidance is going to be at the point in time this issue would fall to be considered. But what the point of the policy is, and it now is made clear in the proposed modification that we provided, is that, in very simple terms, if you've made more money than you thought you were going to, because your income has exceeded your outgoing in relation to it, whatever that is, should be considered for the purposes of the clawback. We have proposed in it a cap, that the cap is obviously achieving full policy compliance. We couldn't do anything other than that because clearly it wouldn't be lawful. It has to go to whatever the policy requirements are. And so the policy itself does what it needs to with the modifications that we've made in light of that. Then in terms of the supporting text and adding some clarity as to, or not adding clarity, adding some further detail as to what will be required by the review, the proposals we've made in relation to the supporting text are that for schemes under 50 units, the review is a review of GDV against original costs plus construction prices index, normal profit and land value. So those are the limited scope that you have regard to on schemes less than 50 units. So that is the lighter touch. You don't need to consider what does lighter touch mean. It tells you there. And then for schemes over 50 units, it's a full reappraisal. And so that means what it says, it's a full reappraisal. And so we're comfortable that therefore does what it needs to do. Note the suggestion in particular that might benefit from some reference to this being done by 106 agreement. Got no objection to the addition of wording to that effect. We're happy with that. The notion of I call it profit sharing, I'm not sure that's really the term of art, but that notion is obviously not something that we've proposed in the main modification, but we can go away and consider that if you would like us to. Just note, though, that the consequence of such an approach would be, in essence, that you've made a finding that the scheme could do what it should do under policy, but then you're saying you don't have to do it. There's sort of tension there in that the profitability has demonstrated they could have, for example, delivered full affordable housing, but then you're not actually then requiring them to deliver full affordable housing following the review. But if you would like us to, we can consider whether or not that some sort of wording in that regard would be appropriate. Going back then to just the three specific points that were made about the other parts of the policy. Any contribution sought through any Section 106 agreement under this plan would have to comply with the relevant legal tests, because that is a question of law. The policy as drafted does, apologies, I've just lost the policy at the moment, does currently refer to the final wording of part 1 before you then get the list. There's subject to statutory processes and regulations, so there is an acknowledgement of you would have to do this in accordance with the relevant legislation. I'm not sure whether there is actually therefore a need to do anything else, but in any event you would have to act pursuant to whatever the law is, because that's how the law works. The development plan can't change the law. The point made about land and build costs, one of the things that is referred to is capital costs. So, I mean, I would have thought that falls within that. And in terms of the need for a list per se, and whether or not there are management / maintenance contributions that can be justified, well, I think the point that was made was it's very rare that they can be, but that means there are circumstances in which they can be, and whether or not in any given application the management costs that were sought were justifiable, that would fall to be assessed on an application by application basis by reference to the relevant legal tests. But by having something in the policy, It just adds a degree of clarity that management costs, where appropriate, management or maintenance, sorry, where appropriate, are something that might be pursued via a contribution. I appreciate they've not responded to every single point that was made on the other side of the room, but I hope that's a sufficient response to the points that have been made.
The other part of the modification, so of the policy that you, not on section 4, but it's, you've already put part of the modification that there's some other wording, isn't there, that you've put forward as a modification to the wordings of those other parts of policies that are set out in your consultation statement that I don't think are in your topic paper, because your topic paper deals with the review part.
Yes, I mean, I focused there on the review part, and I've been doing that by reference to what we say in S7, but I think that's right, that there are wider or other additional modifications proposed to other parts of the policy.
Yeah.
But, you know, given what was said, I focused there on
I understand.
the review mechanism point.
Okay. Are there any points that you wish to make in addition to, on this side of the table to what you've put to us and what we've heard? Yeah. So, Mr. Humphries, you said you'd be happy to have a look. I understand the points you've made just now, but you might want to have a further look at some of those points.
Yeah, I just, in this, I'm always conscious that in this context, there's a temptation to keep fiddling with policies to get a perfect form of wording, whereas what you're actually concerned with is it sound?
We're not here to improve the plan. There's just, yes, we're testing soundness.
But given this is something where we have already proposed a main modification, so a view has already therefore been taken that there is a need for some additional wording for the purposes of soundness, I'm content that we just go back, check for completeness whether we're content with what we've proposed already, whether we think a sort of further slight refinement would be sensible. So I'm not saying we will come back to you with some additional wording, but I'd just sort of flag that we'll have a think about it, and if something comes out of that thought process with which we need to sort of propose a further modification, we will do so.
Yeah. You've already indicated that you think that wording in relation to section 106 should go in anyway.
Yeah, well, I think the indication I tried to give was that seems sensible to me, but I'll speak to those who sit alongside me as to whether or not, and what, if so, we would actually propose some wording.
Okay. So what will that'll be an action point for you then to look at that. Okay. Okay. Well, thank you very much for your contributions, and thank you to this side of the table for setting out your concerns clearly, and thank you for the discussion. That concludes today's session. No further points. Mr. Humphries, is there anything you wish to bring to our attention before we close?
No, so I think it'd probably be sensible off the back of today. I think we've got a few more than we did yesterday for the task list, so I'd suggest it would probably be helpful for us if we had a similar admin session now to how we did yesterday. I just, whilst everybody else is here, in terms of the existing allocations document that you requested, we've got a almost final draft, but what we'll do is once we finish, we'll take the time to sort of sit down and go back through that once we can all do so, because we're not sat here talking to you, and then get you later this evening a version of that document. Yes, the existing Yes. Well,
This is to do with the carried forward allocation.
exactly. Yes. Not the commitments.
We want, because it's relevant to our discussions tomorrow.
That's
Exactly.
Right. You said you'd get it for us to tomorrow, yes, that's right.
Yes. So we're almost there. We just need to, once we finish now, go back through it to check that we're all happy with it.
That's fine.
Okay, thank you. Okay, so we will adjourn now, and if we, I've just told the admin meeting in here, after 10 minutes. So, 4:15. So that's the end of the session today. Thank you for your contributions. As Mr. Humphries said, as of yesterday, we just going through with the council the actions that, there's a number of actions today that we said will happen. Mainly the council will undertake a certain piece of work. That's just to make sure with the programme officer that we've recorded them all correctly. We're not discussing them, but you're welcome to stay and observe if you wish. Thank you very much, and for those of you here tomorrow, we'll see you tomorrow. Thank you.